A couple minutes.
Thank you.
Very welcome.
Looks like we are convened as a committee and our live stream has activated. So good morning, everyone. This is the Joint Standing Committee on the Judiciary. We are going to take up 2 bills this morning, and then this afternoon we are going to have a presentation by a number of the chiefs and Ambassador Dana from the tribes in Maine. And so we are going to start with our usual round of committee introductions, and I will call on committee members to introduce themselves. See, we'll start with Senator Sanborn.
Good morning, everyone. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
And Senator Keim is not able to be here this morning due to power and internet unavailability. So then we'll move on to Representative Babbage.
Thank you, Madam Chair. My name is Christopher Babbage. I am serving my 6th term in the legislature, my 3rd on judiciary. I represent House District 8, and that's most of the town of Kennebunk.
Thank you. Representative Reckitt.
Thank you. My name is Lois Reckitt, and I am proud to represent District 31, which is the ocean end of South Portland. This is actually my 3rd term on judiciary as well. I also serve on the Criminal Justice and Public Safety Committee. Thank you.
And Representative Moriarty.
Good morning, all. I am Steve Moriarty, representing my entire hometown of Cumberland and part of Gray.
Representative Sheehan.
Good morning, everyone. My name is Erin Sheehan, and I represent House District 12, that is part of Biddeford.
Representative Downs.
Good morning. Thank you, Madam Chair. My name is Kathy Downs. I represent District 130, which is Bucksport and Orrington. Thank you.
Representative Libby.
Thank you, Madam Chair. Good morning. I'm Laura Libby, and I reside in Auburn. I represent District 64, which is part of Auburn and all of Minot.
And I heard earlier from Representative Poirier, and she likewise is without connectivity due to the storm. Representative Evangelos.
Good morning, everyone. No power or internet at home, so I came to Augusta. Lucky I wrote my testimony yesterday. Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you very much. And I believe that some other committee members may also be having connectivity problems. Let's see, turning to co-chair Tom Harnett, would you like to introduce yourself?
Thank you, Madam Chair, and good morning. Welcome, everyone. My name is Tom Harnett. I represent House District 83, which includes my hometown, the city of Gardner, and also the town of Farmingdale. And happy to be with you all today.
And I'm State Senator Ann Carney. I represent Senate District 29, which is very windy today. When my mic is on, you may be hearing the wind actually whistling through the windows of my office. But I am very happy to be here today and looking forward to the 2 bills that we have public hearings on this morning. So with that, the first matter that we will take up is actually LD 411. And I will turn to Representative Harnett. Did you have a motion, Representative Harnett?
I did, Madam Chair. Thank you. I move that we table this at the request of the sponsor.
Is there a second?
Second.
Thank you. All those in favor? It's unanimous. Thank you very much. LD 411 is tabled, and we will let members of the public know when that is going to be taken back up. That we then are moving on to, actually, hold on a second. I just want to make sure that I have the bill order correct. Our next bill is LD 478. Is that correct, Tom?
That is correct.
Thank you. I have two different lists, one in numeric order and one in the correct order. So LD 478 is an act to establish a fund to compensate unjustly incarcerated persons. And our committee member, Representative Evangelos, is presenting that bill. Representative Evangelos, you welcome to the committee and you may proceed.
Thank you, Madam Chair. Good morning, Senator Carney, Representative Harnett, and other distinguished members of the Judiciary Committee. I am Representative Jeffrey Evangelos from Friendship, and I represent House District 91. This also includes Washington, Waldoboro, and the town of Union. I am speaking today and introducing LD 478, an act to establish a fund to compensate unjustly incarcerated persons. As the summary indicates, this bill creates the Unjustly Incarcerated Persons Compensation Fund and establishes compensation amounts and a process for the application for and determination of compensation. The bill establishes compensation of $50,000 per year of unjust incarceration and $10,000 for each year that a person eligible for compensation was required to register as a sex offender. According to the National Registry of Exonerations, police and prosecutor misconduct, and I quote, contributed to false convictions in 54% of exonerations, usually with more than one type of misconduct. New York Times, September 16th, 2020. This is exactly what was happening in Hancock County here in Maine, when federal judge John Woodcock cited that prosecutorial district for malicious prosecutions in an opinion he rendered March 12th, 2019, Bangor Daily News. This bill was taken up by the Judiciary Committee in 2019 and 2020 and was the focus of an extensive work session in July of 2020. The Innocence Project assisted me in the development of the language for this bill. The committee was unanimous for its support of the concept, although there was a minority report ought to pass, which proposed lower amounts of compensation. The final vote last summer was 9 ought to pass as this current bill is written, exact language, 2 ought to pass as amended, and 2 absent. I also want to note that there was no testimony or opposition entered at any of the public hearings or work sessions in opposition to this bill in the previous legislative session. Unfortunately, when we were not called back to finish our work in 2020, this bill joined the hundreds of others that died. This bill will also repeal 2 onerous provisions of Title 14, Sections 8241 to 8244. The current law, as written, contains 2 requirements beyond the exoneration of an individual. First, the current law requires the victim of unlawful incarceration to obtain a formal pardon from the governor. Good luck with that. And then adds an additional burden on the victim, requiring she or he file a superior court action. Since most residents of prison are broke, requiring them to obtain an attorney for a superior court claim is unreasonable, as is the pardon requirement. As the exonerated Tom Bledsoe of Kansas said, excuse me, before I was locked up, I had 40 acres, livestock, a wife and kids. When I was released, I had nothing. I lost my family, my job, my reputation, everything. That's a difficult article to read, Madam Chair, I'm sorry. Topeka Capital Journal. When the committee completed its research in 2020, it was discovered that no Maine person has ever succeeded in overcoming these burdens. No exonerations, no pardons, no money. Additionally, the current law has a damage cap of $300,000. So a person who was unjustly imprisoned in Maine for 30 years receives just $10,000 a year, hardly a recipe for justice. Maine's current law ranks our state near the bottom in adjudicating a fair and reasonable outcome. I've given you a bunch of data. There's some attachments to my testimony, and there was an attachment that came in with my testimony. The others are at the bottom. There's links for you. 35 states have already adopted some types of these standards. And I want to be clear about something. The intent of this bill is to honor judicially mandated and ordered exonerations. This bill is not about pardons. I have attached the 50-state survey on this subject for your review, along with some additional data and documentation. I guess that concludes my testimony. Thank you for your consideration. I'll be happy to answer your questions and would look forward to working with you in the work session.
Thank you very much, Representative Evangelos. We appreciate you presenting the bill to us today. At this point, I'm going to turn to committee members and ask if there are questions for our colleague, Representative Evangelos, and there are a number. Representative Libby, you may proceed.
Thank you, Madam Chair, and thank you for that presentation, Representative Evangelos. I am starting from scratch here because I wasn't here for the previous session when you guys did so much work on, I believe, a similar bill. So I just am wondering, as you've done your research on this, I know you're very knowledgeable on this issue. How often has it happened in Maine in the past, say, 10 or 20 years that that someone would fit the bill, per se, according to this, that it was reversed or vacated or found not guilty, but then obviously didn't meet those other standards that have been in the law up till now?
Well, thank you for that question, because now it relates to a matter that was unrelated to this bill. But last session, when we heard this bill, we also heard a companion bill. They were kind of hitched together at the hip. And that's a bill we're going to be hearing a little later this session. That one also died last summer. But that's a bill entitled An Act to Reform Our Post-Conviction Appeal Laws. Maine has a very arcane and unfortunately difficult post-conviction review process. Unlike most states, if you're innocent and stuck in prison, you have time limitations imposed on you for the introduction of new evidence that would exonerate you. And it's common practice by attorneys in the Attorney General's office to assert something called the due diligence standard. And that simply works like this. The prosecution side will simply say, well, your first lawyer should have discovered this evidence when your original trial occurred. And this other bill that we're introducing, which did pass the committee nearly unanimously, will remove any impediments on the introduction of this evidence that would clear people. It's based on a Massachusetts criminal code called Rule 35B, and I'm not going to take credit for it. David Carroll from the Sixth Amendment Center brought that language to our attention. There's about 32 other states that have already adopted that standard. And I'll put it this way, we have a cold case homicide squad, searching for people who murdered people, and that the cases are unsolved. We don't impose any limitations on evidence for those cases, but when you're stuck in prison, we do. So the direct answer to your question is never. Because of the draconian nature of our appeals, we've never been able to recognize that our system has made mistakes. Now, we all listened to the Sixth Amendment Center report and Commission on Indigent Legal the other day. I don't think anybody could come out of that session not believing that we've made some mistakes. We've had ineffective legal counsel, the inability to introduce new evidence. So these two bills are companion bills, and they were heard and adjudicated together in a work session. That's not the case this year, and that's why I wanted to take the time to explain that to you, even though technically it's out of order. But I have to explain to you why these people have not gotten out. The closest we came was in 2017, when Justice Wheeler ordered Anthony Sanborn released from the Maine State Prison after serving a 27-year sentence. He was well on his way to exoneration, but the state insisted that they were going to try him again, despite overwhelming evidence of his innocence. He had missed out on everything in his life, and he simply took time served just to get out of prison. I hope somebody who is testifying today can weigh in on these injustices. It's just a terrible situation. We see these images across the country with the unfortunate person standing on the courthouse steps, a defense counsel on one side and a prosecutor on the other. And they say, today we got it right. That hasn't happened in Maine. And so we're trying to correct the situation.
So thank you very much, Representative. Just to be clear, so not only has no one ever met that standard of also being I'm sorry, I'm forgetting the three standards, additional, the formal pardon from the governor and the superior court action, but you're saying no one has been reversed, vacated, or found not guilty, except for that one case in 2017.
Right, and that was time served. We had the Vladeck Filler case in Hancock County, and I mentioned Judge Woodcock's opinion. Filler did receive an exoneration. He was falsely imprisoned, but his imprisonment was, I think, 30 days. So he filed a civil rights superior court action against the counties and against the individuals. He ended up with two settlements, a $375,000 settlement against Hancock and Washington County and their prosecutors, and a $1.8 million settlement for those that lied him into prison. He didn't take advantage of the current statute because his incarceration was limited. Mm-hmm. Although the damage to his reputation was permanent. He was accused of sex crimes that he didn't do by a malicious prosecutor who knew he was innocent and who was sanctioned by the Maine bar for 7 different infractions. So this bill will just get us up to standard of what's happening around our nation. As you saw the example I gave you in Kansas with Mr. Bledsoe. We are having successes. I work with the Innocence Project. These reforms are working. And there is no interest in the justice system to keep the wrong person in prison. And you're going to see as this session proceeds that there'll be several bills trying to reform where we are here, because we are in a bad place in the state. Thank you for those questions.
Thank you, Representative. Thank you, Madam Chair.
Thank you for your questions. Representative Babbage, you may proceed. Representative Babbage, you're still muted.
Thank you very much. I'm sorry about that. Thank you, Representative Evangelos, for bringing this forward. I missed an opening statement you made. False convictions and 54% of exonerations. Could you say that again so I could understand exactly what it sounded like an important statistic that you led with?
No, I don't remember exactly saying that. I think I said there were 35 states that have adopted standards similar to these, and including the federal government. But I don't remember anything about 54.
Okay.
If there's another member of the committee that can refresh my memory, I'm open to it, but I don't remember saying that.
Okay, that's not part of what you wrote in testimony. I may have misheard. I thought it was at the top.
Representative Babbage, I'm sorry to interrupt you, but it looks like Representative Harnett may have something to contribute regarding that specific point.
Thank you, Madam Chair. On the first page of testimony, the fourth full paragraph, the statement was, according to the National Registry of Exonerations, police and prosecutor misconduct, quote, contributed to false convictions in 54% of exonerations, usually with more than one type of misconduct, citing the New York Times from September 16th, 2020.
That's correct. I'm sorry, I'm a little discombobulated. I had no power, but that is correct. I did cite that. Thank you, Representative Harnett.
Yeah,
I'm sorry.
Go ahead, Representative Babbage.
Thank you. So I'm sorry, I didn't know your testimony was already available to us. I apologize. Haven't seen that yet.
Came to me this morning.
Okay, thank you. Jeff, the only other thing that I in the bill, and I don't recall if we discussed this last time around, but in a judicial process, we usually deal with guilt or not guilty beyond a reasonable doubt. So does the certificate of innocence make more subjective? Is there any, do you see any difficulty in having a certificate of innocence if in fact the injustice is that they really didn't have enough evidence to prosecute and it shouldn't have gone forward, but that innocence is not established?
Well, everyone in this country is innocent, beyond a reasonable doubt, unless you have evidence beyond a reasonable doubt. So I think what happens is once and this would obviously be a superior court, makes its findings of innocence or exoneration, or the prosecution throws the towel in, then the district court just issues this certificate. That's just the process. I understand it is the way the bill goes. So the district court issuance of the certificate does not have anything to do with the hearings that were held to establish the charges and the incarceration being thrown out. It's a step that comes later. It's just sort of a certification process. The Innocence Project in the states they've worked with does have several standards, but in the Filler case, strangely enough, his exoneration went back to the prosecutor, and they said, we have no further interest in prosecuting. So they can always take a second bite at the apple. That's what they threatened Anthony Sanborn with. And, after 27 years, he's in a really bad place in that case. And that case was a tragedy. He was clearly innocent. The evidence from the police detectives were found hidden in the attic of Portland detectives. The witnesses who accused him came forward and said it wasn't him. And the state still insisted that they were going to retry. And so he was faced with, losing again, possibly. So I know I've had this argument with the Attorney General about this, that he should have pressed on, but that's easy to say when you haven't been the one sitting in prison for 27 years. So the certificate of innocence just is issued after a higher court has reviewed the appeal and made the finding that there was either insufficient evidence or no evidence to justify the conviction.
Thanks for that clarification. Appreciate it.
Representative Harnett, you may proceed.
Thank you, Madam Chair, and thank you very much, Representative Evangelos, for introducing this bill and your testimony today and all the work you've done on these issues. You used two terms in your testimony, and I think there's an important distinction between them that I'd like you to explain. The one term is the power of the executive to pardon, which is vested solely in the governor. But you also talk about judicial exoneration, which is an act of a separate but equal branch of government, the judiciary. Could you explain why that's an important distinction?
Yes, we have three branches of the government, and the power of pardon would occur for somebody who is either still incarcerated or has finally been released from prison and has been pardoned after the fact, or in the case of Mr. Geller's pardon posthumously. However, when a court finds somebody not guilty, it's no longer subject to the governor's powers of pardon. And as Senator Carpenter suggested last summer, why are we even leaving the pardon power in this bill when the courts have made a finding? Clearly, the courts have their separation of powers, and when the courts make a finding that you're innocent, there should never have been a requirement to obtain a pardon. You don't get a pardon for being innocent. I hope that explains it.
Thank you. May I have one follow-up question, Madam Chair? And this goes to the point raised by Representative Babbage about why an innocence certificate. And as you mentioned, everybody in this country is innocent until proven guilty, correct? That's the standard. Once that guilt has been removed, all the innocence certificate does is return you back to where you were with that constitutional protection, which is innocent until proven guilty. Is that fair to say?
Yes, that's correct. And I think the role of the district court in this bill is to just set off the process. I think the person has now 2 years to establish their claim. And by the way, the fund, if you want to know where the money comes from, is it's undesignated fund surplus. No need to raise new money for this. I don't expect this to happen a lot, but when it does happen, it's so important.
Thank you, Representative.
Thank you very much, Representative Harnett. Representative Moriarty, did you have questions?
Thank you, Madam Chair. Representative Evangelos, just as a matter of sort of history and housekeeping, is this text the same text that was before the committee last summer?
The text that is before you today was the amendment introduced with the help of the Innocence Project at the work session. The bill that I introduced was too weak, and people came to me and said, you need to do better. And then the Innocence Project and Peggy's assistance helped me put together a draft based on Innocence Project language that has been used successfully in other states.
Well, specifically in your comments, you mentioned that there was a final vote of 9 in favor of passage. Was the committee voting on this same text as we have before us today?
That is correct.
Okay, all right, that's what I wanted to clarify. Madam Chair, I have another question, but I can defer and give other folks a chance to weigh in.
I'm not seeing any other hands raised at this point, so go ahead and proceed.
All right, okay then. Representative, looking at page 1 of the bill, section 22-102, 1B4, down toward the bottom. And I have a question about a conviction resulting in whole or in part from a confession. And I need to be sure, I'm a bit twisted around by the language of that subportion, and I wonder what, if a conviction is based upon a confession, does the bill say that the conviction can nevertheless be overturned and that the individual is entitled to benefits?
That is correct. What they're saying here is, I know in the Sanborn case, this is exactly what happened. I believe he may have been badgered into incriminating himself. And we know about these cases around the country where the police will interrogate you for 3 and 4 days and then finally tell you they're going to give you a good deal. And so you say, okay, I did it, when you didn't do it, in fact. So that's what this paragraph is addressing, so that you're being held harmless for making a false confession and in effect having perjured yourself, that you're entitled to the relief if you were pressured into confessing something you didn't do.
Okay, thank you.
I do want to add one thing. There are several men in the Maine State Prison I know right now who have always maintained their innocence and who are seeking appeals. And beyond the whole scope of this, you just can't imagine what it's done to their families. It's devastating. Thank you.
Are there other questions? I have a question for you, Representative Evangelos. Actually, 2 questions, but picking up on what you just said, could you please give us an example of the impact that it's had on people's families? That I think that would help us understand the context and the importance of the underlying policy.
Thank you, Senator. It's a good question. I think one of the best ways I can describe it is Anthony Sanborn testified at our post-conviction hearing in 2019. He was the gentleman that spent the 27 years in prison. And he missed out on his children. They had grown up, he never saw them. You get out of prison, they're in their 30s. He missed out on his relationship with his wife. He missed out on his opportunity to earn a living. Maine median income in Maine is somewhere between $30,000 and $50,000, $60,000, depending which county you live in. He was prevented from the opportunity to have a job, earn a living, do all the things that we do every day. Go to ball games, go fishing, go skiing. Just you are prevented from your humanity. But the worst thing he spoke about was the fact that his two little kids, he missed out on their lives. And as Mr. Bledsoe said in Kansas, oftentimes the family will abandon you in a case like this. They think perhaps you were guilty. In Mr. Bledsoe's case, his own brother lied about his involvement and ended up, the crime involved the death of their sister. And he was framed, and his wife and kids believed it. And so it just destroys you. I don't know if there's any coming back from it.
Thank you. I have another question that is at the complete opposite end of the spectrum from the one I just asked. And I just really appreciate you answering the previous question. This is a very nuts and boltsy kind of thing. You had said in response to, I think it might have been Representative Harnet's question, you made a reference to there's no need to raise new money to implement this legislation. And I'm not sure if I heard you correctly, but could you please elaborate on that or clarify my misunderstanding? Thank you.
Sure. On section 1524 of the bill, right at the top, the compensation fund receives funds allocated or transferred by the legislature from the unappropriated surplus of the general fund. So that's why I made that remark. So in these rare cases, the compensation would be tapping in to a surplus. The next question is, I don't know what kind of a surplus we're going to have after COVID, but irregardless, what's happened in several other states is we have this thing in Maine called a private and special law. Occasionally, when an individual cannot get relief from the state under any other means, and in other states, occasionally a legislator would introduce a private and special law to address the compensation if the state doesn't have the money. And then both houses of the legislature would have to address that. We've dealt with those bills before, but not on the criminal justice side. It's usually a property damage thing that the state may have inflicted on somebody, or an unconstitutional taking, things of that nature. So that would be Plan B if there is no money in the surplus.
Thank you for clarifying that. Representative Libby, did you have another question to ask?
Thank you, Madam Chair. Mine is also a nuts and bolts question pertaining to this, the fund. So is the fund, is there money currently in the fund, or is this simply a fund in name only at this point and it is filled when needed, or I guess what's the status of that?
There's currently, I don't have the exact numbers, but according to the finance director for the state, there is money in our surplus currently still, and I know that it was the subject of some controversy that they're keeping money in the rainy day fund. A lot of people have argued in the last year that it's pouring out, and we need the rainy day fund now to help our people through this crisis we're living through. But so I know for a fact there's still money in the surplus.
So to clarify, so the money is in the surplus, not in a special bucket that's
right.
The
unappropriated or undesignated surplus of the general fund. It's on the 1524 top line of the bill.
Thank you.
Thank you. That was a great question. Representative Libby, you actually helped me clarify my understanding as well. Are there other questions on the part of committee members? Representative Moriarty?
Thank you, Madam Chair. Just to follow up on that last series of questions, are there other claims, standing claims to the unappropriated surplus fund? Is it earmarked for other purposes? Or is it and if, well, whether yes or no, how much of the fund or what percentage would go to the new compensation fund?
Well, to answer the second part of your question, we're not going to know until somebody is exonerated and we determine how many years they were in prison, and then we do the multiplication. To answer your first question, representatives and senators are always clamoring for a piece of the surplus to, for instance, why aren't we supplying more money for revenue sharing when there's money sitting in the bank in this time of crisis for our towns? I don't have the exact numbers, but I do know that there was a discussion recently of why are we keeping money in the rainy day fund? So I know that there is some money there. And every year we're required to end the year with a surplus, you know that. And so every year there's this calculation, there's a word for it, it's the cascade, I guess, where they determine where the surplus is going to go. And so the annual surplus, just like in a municipality, the town ends the year with a undesignated fund balance that goes to surplus, and then the selectmen have to determine what they're going to do with it. Selectmen and women, sorry. And it doesn't operate much differently at the state level. Legislators make their feelings known. The Appropriations Committee, can take some action, and ultimately they have to work through the Chief Executive's office to make that final determination of what to do with it. But this would be a claim on that fund, clearly, if we had one of these people.
Okay, thank you.
Thank you, Representative Moriarty. Before I'm going to ask committee members if there are any final questions before we move on to members of the public, but I did want to give Representative Newell an opportunity to introduce herself.
Thank you, Madam Chair. Please excuse my late arrival. I was presenting to Marine Resources this morning. I'm Tribal Representative Rena Newell. Thank you.
Thank you very much. Any final questions on the part of committee members?
I have one final quick comment. I got a little emotional today, so I know some of these families, so sorry.
It's a really difficult subject, and we're really appreciate you bringing it forward, Representative. Okay, so our process is that we are going to call first on those who are here to speak in favor of this legislative measure, then those opposed, and finally people who would like to speak neither for nor against. Members of the public have had an opportunity to sign up in advance, and I am going to call on those who have signed up to speak in favor of the measure. You'll be promoted once I call on you. You'll be promoted from attendee to participant and moved into this meeting, and will be able to activate your audio and your video. It's a little bit of an odd transition, so just be aware that you'll feel like you're in Never Never Land for a moment while you're transitioning. So let's see, the first person who is here to speak in favor of the legislation is, excuse me for just a moment, Jan Collins. And you made that transition through cyberspace very quickly. Welcome to the committee, and you may proceed with your testimony. We do set a 3-minute limit, and I'll run a timer. And as you get toward that, I'll show you the timer. After that, you'll have an opportunity to answer questions from committee members.
Thank you, Senator Carney. Representative Harnett and honorable members of the judiciary, my name is Jan Collins. I'm Assistant Director of Maine Prisoner Advocacy Coalition, and I'm here to support LD 478. like Representative Evangelist, I do know many of these people. In 2017, Kelly Walsh et al. Published the results of her research estimating the prevalence of wrongful conviction. Funded by the U.S. Department of Justice, the report analyzed DNA from known origin from cases in the 1970s and 1980s in Virginia, from sexual assault and murder cases. And they arrived at a 11.6% wrongful convictions. Another study published in 2012 by Marvin Zalman, qualitatively estimating the evidence of wrongful convictions, reviewed the literature investigating the possibility of wrongful convictions at each step of a criminal prosecution and concluded that it is likely that 10,000 people may be wrongfully convicted of serious crimes each year in the US. What factors might contribute to wrongful convictions in Maine? There's a long list. Police bias or misconduct, prosecutorial misconduct, faulty forensic evidence, contaminated evidence, false confessions, intimidated witnesses, misidentifications by witnesses, destruction of or withholding of exculpatory evidence, plea bargains, incompetent legal defense, and/or judicial bias. It only takes one of the conditions in this list to be present for there to be the possibility of a wrongful conviction. Most researchers are comfortable using the estimate of 2.5 to 5% of incarcerated individuals being wrongfully convicted. Although the closure of courts due to COVID has lowered the number of individuals in Maine's prison to less than 2,000, let us use that round number to estimate the number of individuals in Maine who are likely to be serving time for a crime they did not commit. If only 1% were wrongfully convicted, that would be 20 people. 2.5% would be 50, and 5% would be 100. This does not include those with lesser crimes who serve their time in Maine's county jails. COVID has provided a unique opportunity for all of us to experience what it might be like to lose a loved one and not be allowed to be by their side as they take their last breath. We have learned to long for the pleasure of spending time with our grandchildren or simply to hug a friend who is going through hard times. How oppressive it feels to consider that our isolation might extend into the future for years. What price would we pay to have another year with a loved one? COVID has provided a window on what it is like to be wrongfully convicted. It has substantial and irreversible effects on the individual, their family, and their community. The guilty person is free, while an innocent person languishes behind bars. Time is priceless. No matter what value we attach to years of wrongful conviction, it will simply be a token, a symbol acknowledging our regret for stealing something more precious than gold. I urge your unanimous support for LD 478, an act to establish a fund to compensate unjustly incarcerated persons. Thank you for your consideration, and I welcome questions.
Thank you very much, Ms. Collins. Members of the committee, are there questions for Ms. Collins? Not seeing any. And Ms. Collins, I have a question for you. You referred
Sure.
to there being the study that estimates 10,000 wrongful convictions each year in the United States.
Yes.
Did you provide a hyperlink to that in your testimony?
I did. Yep.
Thank
To
you.
both of those. Mm-hmm.
Okay, great. Thank you. And I see that Representative Libby has a question for you. Go ahead, Representative Libby.
Thank you, Madam Chair, and thank you for being here today, Ms. Collins. My question is just, I appreciate the links that you've provided to the research. I wonder if there's ever been any research done closer to home in Maine. Has anything along that lines been done before?
I'm not, thank you for that question. I think it's a very important question. There was an author who was writing the story of 4 different individuals in Maine State Prison who have claimed since their conviction that they were innocent, and throughout their conviction that they were innocent. Unfortunately, that gentleman died before he could complete his work. And I have not seen it published or seen the research that he did as well. So as far as I know, there is no study in Maine.
Thank you.
Yes, thank you.
Do other committee members have questions for Ms. Collins? Just looking to make sure there are no other hands up. And I'm not seeing any. Thank you very much for presenting to us today, Ms. Collins.
Thank you for the opportunity to speak. I appreciate it.
And at this point, no one else signed up ahead of time to testify in support of this legislative measure. Is there anybody who has since joined the meeting who did not have the chance to sign up ahead of time who would like to testify in support of this legislation? Okay, I see that there are a couple of participants in the attendee space. And Mr. Pelletier has joined the meeting, but Mr. Pelletier, could you please indicate to us, are you neither for nor against?
Yes, I'm neither for nor against.
Okay, so we're going to ask you to wait just a moment, and if you could mute yourself and turn your camera off for now, please. Thank you. Okay, so I am going to call on Sanchita Mukherjee, and I'm going to move you into the panel. It's just take a moment for you to make that switch to that screen. Welcome very much to the Joint Committee on the Judiciary, Ms. Mukherjee. You may proceed with your testimony.
Thank you so much. Senator Carney, Representative Harnett, and members of the committee, my name is Sanchita Mukherjee. I am a 3L at the University of Maine School of Law and a legal extern at the American Civil Liberties Union of Maine. On behalf of our members, we ask you to vote ought to pass on LD 478 that would allow exonerated people to obtain government compensation for their wrongful conviction and imprisonment. Since 1989, when the first DNA exoneration took place, 375 people have been exonerated based on DNA evidence alone. Many more have been exonerated without DNA. Wrongful convictions happen everywhere in our country. There have been exonerations in 37 states to date. Once wrongfully convicted, it can take many years to regain one's freedom. The average number of years a wrongfully convicted person serves in prison is 14. People who are wrongfully convicted continue to face obstacles after their release. During the long period of incarceration, the wrongfully convicted person was unable to develop essential skills for work, pay into Social Security and unemployment benefits, and build a whole life. With no money, housing, transportation, health service, or insurance, and a criminal record that is rarely cleared, the punishment lingers long after innocence has been proven. And these hurdles can be too steep to overcome. Wrongful imprisonment is one of the most severe deprivations of liberty, and when it happens, Maine has a responsibility to recognize the injustice and harm caused, and to assure the public that the state is willing to take responsibility for this wrong. Providing $50,000 per year is in keeping with the law of the majority of states who provide compensation of the wrongfully convicted. When the state has done wrong, whether intentionally or not, it ought not to skimp on the redress it gives the people it has wronged. Maine has a statute that envisions compensating wrongly imprisoned people, but the standards are too high. A person must not only get a full and free pardon from the governor with a quote written finding by the governor that a person is innocent of the crime for which that person was convicted. And second, a court must find that person innocent. This can be found in statute 14 MRSA section 8241. This committee should change the law to ensure that the standards of proof required for innocence are reasonable and rigorous, but not nearly impossible. Please support justice for all and accountability to the wrongfully convicted and vote ought to pass on LD 478. Thank you.
Thank you very much for your testimony here today, Ms. Mukherjee. Are there members of the committee who have questions? Representative Babbage, you may proceed.
Thank you very much, Madam Chair. Thank you, Ms. Mukherjee, for your testimony. Setting aside the entire question of justice, and I don't usually do that, if we're talking about fiscal concerns, is it likely that, I guess what I'm asking is if the fiscal consequence of a bill like this would lessen over time due to the fact that a good portion of these exonerations have come about because of DNA that wasn't available at the time of conviction. Is that a reasonable assumption?
I would certainly hope so. I would certainly hope that as we progress in time and DNA evidence becomes more available to, more recently imprisoned people, that this becomes less of a fiscal concern when it comes to DNA evidence. That was the reason why someone was incarcerated. But there are other factors, as was testified to earlier, that lead to false imprisonment or imprisonment that occurs when that person did not commit the crime. So I would hesitate to guess as to, what the fiduciary burden is.
Actually, thank you for that. I mean, what I suppose I was trying to get at is at what point, for instance, those 375 people in the last 30 years, do we know DNA was key in the final finding?
I don't know the exact answer to that for all 375. I do know that the average number of years for those people who were in prison was 14 years. Right. And that comes from DNA exonerations in the United States from the Innocence Project. But I'm happy to submit something to you that is more indicative of more recent exonerations and what that timeline looked like for those folks who were exonerated.
Thank you very much for your testimony.
And that would be very helpful to have for our work session, if you don't mind doing that additional research for us. We appreciate it. Are other members of the committee interested in asking questions? I am not seeing any. Thank you very much for providing your testimony today, Ms. Mukherjee. And Representative Evangelos, did you have a question?
Thank you, Madam Chair. No, I just received an email from Walter McKee. He had signed, it says in the email, it just happened in the last 3 minutes.
Yeah, I'm about to call on him. Is that?
Oh, is he hooked in?
Yeah.
He's having trouble getting hooked in. Okay, all good.
Thank you. Okay, the next person here to speak in favor of this legislation is Walter McKee, and I am going to move him into the panel. Just take a moment. And Mr. McKee, it looks like you've joined us. You can go ahead and proceed with your remarks.
Thank you, Senator Carney, Representative Harnett, members of the committee. I'd note I signed up to speak on behalf. I didn't submit written testimony, so my apologies if there was some mix-up there. I just want to walk through some of the key provisions of this bill. I think it's important just to hit the highlights of what this bill is trying to accomplish. It's really coming out of the problems with 14 MRS 8241. And this was identified in the prior hearings on this bill, when this bill was introduced previously, which is the impediment of requiring that the governor not only pardon the individual, but also to indicate and make a written finding that the person is actually innocent of the crime. And when we talk about, geez, how many of these cases have been presented in the first place? They haven't been presented because they can't be presented. And that's because the unique nature of the pardon process. And for those of us who practice in front of the pardon board all the time, we know that the only way that you are going to get that pardon, and it's part of their policies, is you're not going to argue about whether you did or didn't do it. You will accept responsibility for what happened. You will acknowledge that this is not to cure problems in the judicial system or with your conviction. So because of the way the pardons are structured, it's just not possible for somebody who says, look, I never did this crime at all, as part of that pardon process. And of course, the governor always has the ability to do whatever she or he wants, but the practice before the pardon board, and that very strict process, you apply for a hearing, you get a hearing, and you hopefully get one and present it, is one where you must accept responsibility. And that's something the pardon board tells any individual that comes before them and says, hey, you know what? You sound like you're saying you didn't do it. That's not what we're here for. Looking at the bill, there's really the three key components, which is, first of all, you have to get over that hump to have your conviction vacated or dismissed. All right, so you got to get there, which is a pretty far place to get in the first place. Then you, the person, presumed innocent, have to prove by a preponderance of the evidence that the fact, first of all, the conviction was reversed, you're found not guilty, of course, but also you have to establish that you did not commit the offense. So you have to reestablish your presumption of innocence in the first place, and that you did not commit, and that in the course of the process you didn't suborn perjury either. So it wasn't like you had lied about it in the course of your trial, definitively lied, and therefore you really shouldn't be entitled to the benefit of that judgment. And if you can get over all of those, then the court should correctly make a determination that you are factually innocent, because that's the way that you clear your name. You are presumed innocent. Yes, you go back to your present status. But as we all know, as it processes through everything in the system, that point where a judge says that you were in fact innocent of this crime is critically important. And that finding and that statement from the court is something that many people want, most above and beyond all else, to be told by someone, you did not commit this crime, even though at one point you were convicted of it. In terms of the compensation structure, I think that's something that should be the subject of a good debate in terms of what is the correct amount. I think all of us can agree that $50,000 a year sounds like a lot, but there's really essentially no amount that can compensate someone in this position for what they had to go through being imprisoned for a crime that this statute would indicate that they never ever committed. So since I've run over time in the past, I'll pull myself back here and happy to respond to questions. I'm speaking on behalf of the MACDL here today.
Thank you very much. The timer had just gone off, so you're impeccable timing.
For the win.
Members of the committee, are there questions for Mr. McKee? Not seeing anybody raise their hand, but I did actually, Representative Harnett, and then I'll have a question as well.
Thank you. My raise hand feature, once again, is not working. Thank you, Madam Chair, and thank you for your testimony, Mr. McKee. It's nice to see you again. And this may be an impossible question to answer, but I'll give it a shot. You have a wealth of experience with Maine's criminal practice, done a lot of criminal defense work. Do you believe that we have persons in jail that have been improperly incarcerated in jails and prisons?
Yes, I actually do. And I say that from 27 years of doing this work. And those are the worst cases as a criminal defense lawyer to be involved in, is a case where you believe that they are factually innocent and the jury or the judge just got it wrong. There's nothing worse. But for client confidentiality, I could tell you some of those stories. And they're ones that weigh on me today. They're names that I will never forget. And so they're there. Whether this would hopefully allow them an opportunity to address that issue remains to be seen. Thank you for the question.
A follow-up, if I may?
Yes.
Oftentimes when we are presented with national studies, people fairly ask, well, what about Maine? Can you show me that this happens in Maine? And I'm not just talking about criminal law, I'm talking lots of studies on criminal justice, other matters. Isn't it safe, in your mind, is it safe to assume that these problems exist here the same way that they exist in all other parts of our country?
Yes, I think it is. The degree is, I think, different. I think to a certain degree, we do things a little bit better here for a whole number of reasons. I have a lot of faith in most of the justice system that we have. I do not feel it would be fair to compare us to some other states who have horrible records with respect to this. But we've got the same kind of problems here that they do in other places in terms of sometimes juries and judges just flat get it wrong. And that's unfortunate. Thank you.
Thank you. Thank you, Madam Chair.
Thank you very much. I had a couple of questions. One is a kind of a follow-up on Representative Harnett. You said that you are aware yourself of instances where people are wrongfully convicted in Maine. And I just want you to connect that, if you could please, to your earlier testimony about our current pardon process. It sounds like there's just no mechanism for addressing those folks.
There really isn't. If you certainly, you can't go before the pardon board and say you didn't do it and beg for mercy. It's if you even put it in your application, you won't even get a hearing. And God forbid you actually get to the hearing and say that, because it's done. And I've watched it in cases, watching other people present pardons, and I hear the pardon request and I think, wow, this is really going great for this person. And then all of a sudden, it's not my client, they lapse into this, but by the way, I didn't do any of this. I think I should get a pardon. And then it's just, you're done. And the recommendation is made, and that pardon, I should say, is never granted for that reason. And I understand it's a unique process, and that's just the way the show has been. And not just for this governor, but for every governor in the past, 20 plus years. Just kind of the way it is. So
does any process exist currently for people who are innocent?
No, they get to go through well, let's just say that they go through the post-conviction process. So there was a mistake that was made, it was significant enough, and it goes, and the judge decides, you know what, this person never should have been convicted in the first place. And the judge vacates the conviction. The conviction comes back, and the case, let's just say it wasn't retried or whatever it may be. That's the situation that we're dealing with here, which is that person in that specific situation who can prove their factual innocence after the conviction having been vacated for whatever reason, and they can prove their innocence, then they're entitled to that compensation for the time that they were wrongfully imprisoned. I mean, the conviction was vacated. The case was ultimately dismissed. So you have that process, but that's the best that you can do.
Thank you very much. And then you also spoke about the compensation structure, and you said it should be vigorously debated. What is your current, do you have an opinion about the current proposal in this legislation?
I think it's a great start, but it's one of those few times where I say, I'll let you all decide that. I won't weigh in on it as much as I'd like to launch with my opinions. I think actually you all are in the best position to kind of sort all that out. And you've got a lot of information on that. Not a lot you'll get from me out of that, as much as I appreciate the question.
Thank you very much. And Representative Moriarty, did you have a question?
I do. Thank you, Madam Chair. Mr. McKee, I have a question about the multiple step process that's set forth in the statute. And as I understand it, the issue was triggered by a conviction for a Class A, B, or C crime and resulting imprisonment. And then if the conviction is reversed or vacated, or the charges were dismissed, or if the person were found not guilty on retrial, you may progress to the several following steps. My question is this: if someone is retried and found not guilty, wouldn't that person's process end at that point? Would you need to go on to the next two subparagraphs?
Well, yeah, because I believe the language is an and. So you're found not guilty. And I think it's an important distinction. I think the CLAC may have had some concerns about this is, look, you go back and you're found not guilty because the state could not prove beyond a reasonable doubt your guilt. So it's vacated, you get a new trial, great, and you win. All people who win jury trials, defendants who are found not guilty, don't just allow to skip the next steps, because I think that's the important part about where you have to prove up your innocence of separate and above that. So I don't believe it does end at that point. I think you have to go 3 or 4 after that. That's how it reads, and I don't disagree with that.
I guess perhaps I haven't fully understood. If you're found not guilty,
Mhm.
you can't be retried for that same offense, correct?
Right.
So,
Right. So
why would you as the defendant or the former defendant have the burden to come forward, albeit on a lesser standard of proof, to establish your innocence?
Well, because being found not guilty is not being found innocent. It's an indication that the state can't meet their burden of proof. There may have been other evidence that doesn't meet that standard. It may have been more likely than not, I suppose, that you committed the crime. You're still found not guilty. It's because of the high standard of proof for conviction.
Okay.
That's the distinction.
Is it possible a person could end up in limbo? That is, he or she might be not guilty under the criminal standard, and yet might not be able to prove his or her innocence.
Sure. Yeah. Yet you still have to get over the preponderance. There have been defendants who have been found not guilty who have been later sued under a civil standard for committing the very crime. And we can remember cases from 20 plus years ago where, yeah, found not guilty, but you were still sued and you were found to be civilly responsible. This is something similar to that, except that here the defendant himself or herself has to go before a court and prove by a preponderance of the evidence. So you may not be able to prove it up. You got to win on both prongs. Good
Sure.
question.
Okay. Thank you.
Representative Reckett, do you have a question?
I was sitting here thinking about the one time I've been involved with this issue. And I don't think I've ever talked to Representative Evangelos about that. And it's not directly on point, but it's very close. And I just want to share with people the difficulty of all of this piece. I was involved with a case of a woman who was convicted of killing her father. And I had spent a lot of time trying to figure out what to do. And I ended up at the pardon board. So I've been once at the pardon board, which I'm going to tell you is pretty darned intimidating, even if you're not the person trying to get pardoned. But it was really an overwhelming experience. And it took a long time for me to even get this person to the pardon board, never mind to get the governor at the time to pardon her, which took me 5 years, I think, to convince. That's to say I had to wait till the governor was into their second term before they would even consider it. But the reality is that it's a very difficult piece around pardons, around I mean, this woman was guilty and didn't try to claim that she was innocent, but she was tried in a 12-minute trial, or 16-minute trial for murder. And to me, that was just unbelievable. And yet it was true. And I blame that on the prosecutor. But the difficulty is all of these processes people are faced with them who have no skills to deal with them. I'm not an attorney, and I was totally intimidated by this whole process, but I carry on. So I kept right on going, but I was not the person accused. I was trying to help someone who had been. And in the midst of a whole national effort at the time to get a lot of women released who had been convicted of murdering their abusive partners. And so there was a whole national focus on it. And now there's not even that, in my view. So it's just, we have to understand that the people who can get to the place, never mind not have an attorney to represent them in Superior Court, not to mention have someone to be with them in a pardon hearing, and to get through the political process of figuring out when the governor might do such a thing, depending upon the nature of the person who was convicted. In this case, it was a Native woman I was working with, and it was, very difficult because the governor at that time was from Northern Maine. So it was. So
ju-
anyway, I'll shut up
I
now.
apologize for interrupting.
no,
but
I know.
Did you have a question for Mr. McKee?
Well, my question is the process still as convoluted as I remember, or is it the same kind of convolution that that I was experienced? Is that the same kind of process that someone has, or overwhelming process that someone has to go through to prove this?
On a pardon, yes. And so the process is you have to prepare the petition and try to get a hearing. And that's the most important piece. It's not something that I recommend people do on their own. Because remember, the pardon process is not just that, did you commit the crime and accept the fact? Has enough time gone by that you've proven yourself to be worthy of a pardon? And then also, critically, what extraordinary circumstances have you shown to suggest that you should get a pardon? What is it that this conviction is doing to your life in a way that is really causing problems? If you don't have that, if you were convicted 50 years ago and you got the Congressional Medal of Honor in between them, if the conviction didn't have any impact on your life now, hey, you know what? I've done great otherwise. You're not going to get a hearing because you haven't shown the extraordinary circumstances for a pardon. And I ask anybody who's interested in that process, you can simply go on the governor's website. It has a part that talks about what is executive clemency, what is a pardon, and it has all these different things that you need to be aware of, and you have to hit every single one of those. And if you don't hit one, you're not going to get a hearing, much less get a pardon in the first place. It's a unique process.
Thank you very much, Mr. McKee. Lois, did you have a follow-up question? I'm sorry, Lois, you're muted.
Right, I'm just curious as to whether there's an intersection with this bill in terms of people who were unjustly incarcerated. I mean, I'm not, I understand that you can't go to a pardon board and say I'm innocent, but I mean, in this case, we're asking people to prove that they're innocent or not guilty. I get the distinction, but we're still asking them to do the same kind of extraordinary effort, in my view. And I want to know from your perspective, as well as frankly the sponsors, whether my perception is accurate.
So it's a major process. This is a major process, but I think correctly so. And I think the standards are correct here because we're trying to address something that significant that's happened in the first place, and proving one's innocent after a pretty major process should involve hitting a number of these steps. I think it's going to be difficult for somebody to do this without a lawyer, frankly. I think these standards are unique. It's be hard to do that. But for an attorney who practices even for a short period of time, they should be able to sort this out enough to be able to prove that. It's no small task. You got to get all the old records, all the other information, because you got to prove your factual innocence. So yeah, let's be realistic here. It's a major burden. And so anybody thinks that this is just going to happen automatically once somebody's found not guilty, I don't think that's the case at all. I think we're going to see very few cases, but it's a process I think is a good bill, and I think it should be passed accordingly.
Thank you very much. Representative Evangelos, did you want to also respond to Representative Reckitt?
Yes, thank you. Just very briefly, the one standard that has been removed in the current language is the pardon hurdle. We discussed that extensively, and last session we had the advantage of having a former Attorney General in our committee, and so he was always able to provide valuable insight, and it was his conclusion that we just need to get rid of the pardon piece of this altogether, because it is, Mr. McKee has already stated, it's an insurmountable hurdle, and so that is what we did. As Mr. McKee has stated, there are still some hurdles, as there should be, but this bill is based on language that has been adopted in other states, and it has resulted in some successes.
Thank you very much. I am not seeing any additional questions for Mr. McKee. Committee members, just checking in with everybody. Any final questions? No? Okay, thank you very much, Mr. McKee. And then I'll just make the final call for anyone who has appeared in our electronic meeting today who wishes to testify in favor of this legislation. And I'm not seeing anyone indicating that that's the case. Is there anyone here who wishes to speak in opposition to LD 478? I think I got the number correct. If you are a participant and you're in opposition to this legislation, please raise your electronic hand. Not seeing anyone in opposition. Is there anybody who wishes to speak neither for nor against? And that, I believe, is Mr. Pelletier, who was with us a moment ago, and I think is returning to our meeting. Okay. Mr. Pelletier, you can unmute yourself and start your camera and proceed. Thank you.
Senator Carney, Representative Harnett, members of the Committee on Judiciary. My name is John Pelletier. I'm the chair of the Criminal Law Advisory Commission. And I'm testifying neither for nor against. I think it's fair to say that the people on our panel were divided, and there's, I would say, a majority of the folks were not in favor of the legislation as drafted. And there are others who favor a process. I don't think they're wedded to the current language. Concerns that were raised in our meeting, first of all, Maine is somewhat unique in separation of powers. Our Constitution, unlike the federal Constitution, specifically says that one branch cannot exercise a power committed to another branch, and the pardon power is committed to the governor. There was concern on our group that the certificate of innocence issued by a court was the functional equivalent of a pardon and could be ruled as a separation of powers by impinging a court or the legislature that authorized the court, impinging on the governor's pardon power. Second, the bill calls for expungement of records for someone who is successful under this bill. In Maine has a long-standing policy against expungement. Expungement many years ago when we had it, turned out to be problematic in that the actual destruction of records caused problems both for the state and sometimes for the person who was the subject of the records and wished that they had the records in order to prove what really happened. And so Maine has a long-standing policy against expungement. Regarding the standard of relief, as has been discussed, our members pointed out that getting a dismissal after being granted a new trial or getting a not guilty at a new trial are not the equivalent of being factually innocent. And I understand that's just one of the criteria, but the other criteria is that the person that demonstrate by a preponderance of the evidence that they did not commit the crime. That is an ambiguous phrase. As an example, you could be convicted of a burglary by driving someone to a residence knowing that they're going to go in and commit the burglary. But the person in the car that never committed a burglary, they're guilty on accomplice liability. So, and the phrase, we've heard the phrase factual innocence sort of used interchangeably in this hearing. And so factual innocence at least has some additional clarity, and perhaps even that could be further defined. And our members objected also to the standard of preponderance of the evidence as too low and potentially leading to frivolous claims that, you know, you could go with a clear and convincing evidence standard or even a beyond a reasonable doubt standard. As a technical matter, there's a notice requirement of the Department of Corrections, but they wouldn't have the information necessary to notify someone of their entitlement. For example, if someone were released in prison and was found not guilty after a retrial, DOC wouldn't necessarily know that. So that's another concern. There were members on our panel, though, who expressed frustration with the current process, the difficulty of getting a pardon and a finding of innocence from the governor, and said that other states have found an appropriate way to do that and did favor the legislature creating a practical way to establish the right to compensation if you can establish that you are actually innocent and were wrongly convicted and imprisoned.
Thank you very much, Mr.
Thank you. I'm glad to
Pelletier.
answer any questions.
Yes, I'm guessing members of the committee will have questions for you, and I see one. Representative Moriarty, go ahead. Yep. Thank you.
Thank you, Madam Chair. And good morning to you, John. I'm glad you raised the issue regarding expungement because I had intended to earlier but neglected to do so. And I want to clarify my understanding of the term. I want to know whether it's defined in statute. And apart from the state's past experience with expunging records, currently, what happens when records are expunged? Is it destruction, sealing, sequestration, or something else?
Maine currently has no statute that I'm aware of calling for the expungement of records in the criminal justice arena. So the records are maintained, and we have statutes, primarily the Criminal History Record Information Act, which is in Title 16, that governs what criminal justice records are confidential and what are not confidential. Previously, we had a statute that allowed someone to get the record of a conviction sealed upon the order of a court. That had very narrow application and was subject to a sunset provision and has since expired. But within the last 10 years or so, I think we had 3 years where you could seal a Class E conviction for theft, but it was very narrow.
Well, to be very clear, what does it mean currently to have records expunged?
On our group, what we understand expungement to be is the destruction of records. And part of it is a concern about governor's pardon power and separation of powers, because if you expunge it, if you destroy all the records, it could be the functional equivalent of a pardon. The court could interpret it as that. And two, records are held in many different places. Courts have records, law enforcement agencies have records. If you have a policy to expunge records, you may destroy all of them, but you may not. And three, in the period in Maine when records were destroyed, the findings are, my understanding, this was before my time, was that the destruction of the records wasn't uniform. So some records didn't get destroyed, but that where records did get destroyed, it created problems in the future for both the state and the person who was subject of the record. So the short answer is we understand expungement to mean you're destroying records. And as far as the people on our panel know, there's no statute in Maine that calls for that with respect to any criminal justice records now.
So would CLAC prefer the preservation of the records?
Yes, and when expungement bills come, and there may be some this session, we generally recommend a requirement that they be sealed, that they be made confidential, and parameters be put around their disclosure, or their disclosure be absolutely forbidden.
That clarifies. Thanks very much.
Thank you, Representative Moriarty. Representative Evangelos, as the bill sponsor under our committee rules, you're eligible to ask clarifying questions. Did you have a clarifying question?
Yes, I have two clarifying questions.
Go ahead.
If you don't think they are, you can tell me, but I think they clearly are. Because we have new members on the committee, I just want them to be aware of what CLAC is. It's the Criminal Law Advisory Commission. And I just wanted to, my aide did a study this morning for me of the membership. And so I want the members of the committee to be aware. And my question to Mr. Pelletier is, according to the analysis done by my aide this morning, 11 of the current 15 members of the commission are either prosecutors or former prosecutors. Could you clear that up as a clarification question, please?
Well, we have, as practicing attorneys, we have 2 sitting DAs, a prosecutor in the Attorney General's office, and 2 former prosecutor as and a member of the Attorney General's office, another member of the Attorney General's office. So we have 5 who are appointed by the Attorney General as CLAC members, and we have 4 criminal defense attorneys, 9 members, and there are 4 consultants who are the 3 are judges, and the 4th consultant, when Mel Czar was the 4th consultant, he was a law professor. The judicial branch nominated Fern LaRochelle, who is a former prosecutor, but expert in the criminal code, to replace Professor Czar. And we have a liaison from the judicial branch who is a former prosecutor, but is not a formal member of CLAC. She attends our meetings and reports back to the judicial branch. Her name is Ann Jordan.
So according to my aid study, the judge.
Representative Evangelos, is this a clarifying question?
Yes, I just want to clarify what he told us, because he neglected to tell us that all of the judges who are on the commission were former prosecutors. I just want to get clear that the commission is not a balanced commission. It is mostly people with prosecutorial background.
That sounds
that's
a little
clarified.
more like argument than clarification.
Well, no,
Mr. Pelletier, can you just let us know, do you know whether the judges who are on the commission are former prosecutors?
We have Justice Anderson. The judges have been judges for a long time, but Justice Anderson, my understanding, was a DA, an elected DA on the coast before he was nominated to the district court. Judge Moskowitz, my understanding, I don't know if he was the elected DA or an assistant DA in York County. And Justice Jabber, when I entered practice, was a well-known criminal defense lawyer. It's possible earlier in his career he spent some time in the DA's office. But Justice Jabber from the law court is also on our panel.
Thank you for that clarification. Are there other questions? Representative Evangelos, did you have another question?
Yes, I just wanted to get clarified on one sentence of his testimony. I want to see clarification on it, if I may. In the second paragraph of your testimony, Mr. Pelletier, you said the certificate of innocence called for by the bill may, and I emphasize that word, may well constitute the equivalent of a pardon and thus a violation of separation of powers by impinging on the governor's pardon power. The first part of the sentence has a may, and therefore that is a speculation. The second part of the sentence, shouldn't that have also included a may?
Well, if it constitutes the equivalent of a pardon, then it does impinge on the governor's pardon power. But it's correct. There's no certainty. There was concern by many of the people on our panel that a certificate of innocence may be interpreted by a court as the equivalent of a pardon, and thus potentially could be ruled unconstitutional if challenged as an impingement on the governor's pardon power. There's no certainty about that. The same thing, I don't think a court has ever said that expungement is the equivalent of a pardon power. But we are aware of the separation of powers. The pardon power is exclusively the governor's, and there's a fair amount of concern on our panel about actions by the legislature that may impinge on the pardon power. Fortunately, well, at this point, we do not have a lot of cases elucidating that, but those are our concerns that I'm conveying to the committee.
Thank you, Madam Chair.
Yeah, thank you, Mr. Pelletier, and thank you for clarifying that as well regarding the concerns of CLAC. Committee members, are there any additional questions for Mr. Pelletier? Representative Harnett has his physical hand raised, and then Representative Babbage.
Thank you, Madam Chair, and thank you for being here again, Mr. Pelletier. It's always nice to hear from you. Did you ever represent clients in front that were seeking a pardon?
No, I did not.
Are you familiar with the process generally, or?
Throughout my career, I've heard exactly what Mr. McKee told you.
So, and part of that is you best not be claiming you're innocent if you're seeking a pardon. Is that part of your understanding?
That is part of my understanding. I'll qualify that just a bit. Is that is part of the process that is set out in the Pardon Board materials. The Pardon Board exists, and that idea, that concept is set out in the Pardon Board materials, and as far as I know, is enforced in the Pardon Board when they decide who gets a hearing, that sort of thing.
So one who is
the thing to note about the governor's pardon power is that the pardon power is absolute, and there is no requirement that there be a pardon board or that the pardon board make a recommendation to the governor. That's a process that has been established, but the pardon power is absolute, so that in reality, if someone made their case directly to the governor, then the governor is not constrained by the Pardon Board or the Pardon Board materials or what's become the practice of the Pardon Board. Now, I understand governors have followed this practice for a long time, and I'm not talking about something that happens every day. But if you're talking about the power of the governor, the power of the governor is not constrained by these procedures that have been developed by the Pardon Board.
Thank you. May I have one follow-up, Madam Chair? The process that you described, this possible process of going directly to the governor, has anybody ever successfully pursued that while they were alive?
Not as far as I know. Although somewhere in the back of my head, I seem to think I've heard of a pardon that wasn't recommended by the Pardon Board, but that perhaps I came from a different state. As far as I know of no case that meets your.
Thank you.
Representative Babbage.
Thank you, Madam Chair. Thank you, Mr. Pelletier. Good to see you again. Could you please elaborate a little bit on CLAC's discussion of the consequence of not raising the threshold from preponderance of evidence to clear and convincing? What can you elaborate on what CLAC is thinking in this regard?
Well, thinking there were a number of folks, and there's nothing mysterious here to Representative Evangelos' point. A number of them were prosecutors, but it's a concept of criminal justice that finality of convictions is important, and so if someone is going to have a court, the feeling was that if someone is going to have a court say, I find you are innocent, that and someone particularly who, having gone through the process, at least at one time was adjudicated, found guilty beyond a reasonable doubt, that standard should be a high standard, and what you need to prove should be extremely clear. And we've hit, the phrase did not, frankly, the discussion focused more on the ambiguity of terms that are in common usage: did not commit the crime, factual innocence, actual innocence, But in Maine, none of those things are set down in paper as to what exactly that standard is. So I think the feeling was, and this was supported by a majority of the group, that one, you need a standard that has a very high degree of clarity, and two, you need a standard that has a high threshold, because evidence degrades over time. Witnesses die. It's common understanding that evidence degrades over time. So that if you're coming to court to say you're actually innocent, you should be able to put on a case that meets a high standard to demonstrate that is in fact the case.
Thanks. I needed to hear the argument. I appreciate that.
Representative Libby, you may ask your question.
Thank you, Madam Chair. I am looking for clarification on the bill itself. I'm not sure if Mr. Pelletier will be the best person or if I should hold my question, but as testimony goes on, is this bill simply scope? Does this bill speak directly to compensation, or is this more broad in speaking to process for having one's conviction and sentence reversed and vacated? And that I just am getting a little bit confused on the scope of this bill. So if I could get some clarification on that, that would be helpful.
Madam Chair, I'd be glad to address that.
If you would please address it from CLAC's perspective, and then I appreciate that question, Representative Libby, and that's the ideal topic for us to discuss at our work session. This may not be the right forum for that conversation. So Mr. Pelletier, why don't you just give us CLAC's perspective, and then we'll defer the remainder for our work session.
What we would understand is this bill is about entitlement to compensation. Although it also has the issuance of a certificate of innocence and expungement of records, which are additional things, but they're about entitlement to compensation. They're not about whether a conviction gets vacated or dismissed. Once you're convicted of a crime, you can appeal. You have a right after appeal in certain circumstances to ask for a new trial on what in Maine is called post-conviction review and what in the federal government is called habeas corpus review. And you're entitled to both of those. So you can do post-conviction in Maine and then habeas in the federal court. The usual, occasionally on appeal or in a post-conviction review, the court finds that you are not guilty, so that there's no new trial needed. But the most common relief is that you're granted a new trial. When it goes back for a new trial, the prosecutor, faced with retrial of the case, can either dismiss the case or they can go forward with a new trial. And at the new trial, you could be found not guilty. All of that is existing criminal process. And all of that is a prerequisite to someone exercising the right that would be created under this bill. Under this bill, before you even go to court and prove to a judge that you didn't commit the crime or you're factually innocent, you have to have been through the process I just described, and either you were found not guilty on retrial or the case was dismissed, or in one of these proceedings, post-conviction review proceedings, the court found that you're not guilty, which is in their power.
Thank you.
So those things are prerequisites and they're not affected by the bill.
Are there any additional questions? Thank you for that helpful clarification question, Representative Libby. Are there any additional questions for Mr. Pelletier? Not seeing any. Thank you very much, Mr. Pelletier, for presenting to us today and answering our questions. And at this point, I believe that we have heard from everybody who wanted to testify in favor of in opposition to and neither for nor against on LD 478. And this is the final call. Is there anybody present in the electronic meeting who has not spoken on this bill but appeared today to speak on it? Okay, I'm not seeing any real or virtual hands. So at this point, the public hearing on LD 478 is concluded, and we will move on to our next bill, and that is going to be, give me just a moment while I switch between screens. That is LD 448. And we have Representative Harnett here to introduce this legislation.
Thank you, Madam Chair. Good morning, Senator Carney and fellow members of the Judiciary Committee. My name is Tom Harnett, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner. And I'm here this morning to introduce LD 448, an act regarding recording of witness interviews. In my mind, this bill is a simple one. Those simple bills can become quite and often unnecessarily complicated as they work their way through the legislative process. Current law requires law enforcement agencies to adopt written policies regarding the recording of interviews of only suspects in serious crimes. This bill would simply extend that requirement to including the adoption of policies regarding the recording of interviews of witnesses. Witness interviews are vital to the criminal justice process, and what a witness says about what she or he saw, heard, or felt plays a large part in a criminal case. Both the prosecution and the defense deserve to have actual recordings of witness interviews so that there can be no question as to just what the witness said. There's a couple points I'm going to make, and I may repeat them. This bill does not require the recording of witness interviews, but it is a small step forward. By requiring that law enforcement agencies adopt written policies for the recording of witness interviews, just like law enforcement agencies are required to now with respect to suspect interviews. There's no fiscal impact by this statute, with this LD, because law enforcement agencies need to adopt a policy, nothing more. While it is hoped that law enforcement agencies would make part of that policy a requirement that some witness interviews be recorded where feasible, this bill is not asking for that step. Again, this bill just requires a policy to be adopted. Recorded witness interviews are critical in the criminal justice process. Having nothing more than a summary of an interview is not enough, as witnesses are important to the prosecution and the defense and to our jurisprudence system. Today, there are no standards for summarizing witness interviews. Law enforcement agencies provide varying levels of detail, from a simple sentence summarizing an extensive interview to a detailed summary of many pages. Nothing can replace, though, an actual recorded interview of the suspect. Again, not requiring that interview, but it does require the establishment of policies about how those interviews will be preserved and presented. With that said, I want to be open about what happened with this bill in the 129th legislature. Though the bill at that time was voted out of judiciary and successfully moved through both chambers, it was vetoed by the chief executive in part on the grounds that it was believed it required interviews to be recorded as opposed to developing a policy. That veto was sustained. My hope is to address those issues that the chief executive was concerned about in the 129th, and to do whatever is needed to work with all stakeholders to make it clear in statute and practice that this is about the development of policies, not mandatory recording. I thank you for time and attention to this matter, and I will do my best to answer any questions you might have. Thank you, Madam Chair.
Thank you very much, Representative Harnett. Representative Evangelist, did you have a question?
Thank you, Madam Chair. Representative Libby's hand was up first.
Oh, go ahead, Representative Libby.
Thank you, Madam Chair and Representative Evangelos. My question is simply if the wording is the same in this bill as it was in the previous session, or if there are any changes and it was simply an issue of what it was perceived to be.
The wording is exactly the same as it was in the 129th. If that confusion remains, I am comfortable with clarifying that through an amendment if that's what results by working with the stakeholders on during the process. But it is exactly the same bill.
Thank you, Representative Libby. Representative Evangelos.
Thank you, Madam Chair. Thank you for bringing this bill forward, Representative Harnett. Representative Harnett, have you read the recent 7-part series in the Bangor Daily News regarding pretty serious misconduct in a variety of sheriff's departments in the state?
Yes, I have.
Has that added to your concern that these recordings could be a valuable protection for our criminal defense establishment?
I would say I had that concern before reading that article, that series of articles. Those concerns may have been heightened by some of the material that I read, though, that was presented by the Bangor Daily News.
Thank you.
Are there other questions on the part of committee members? I do have a question for you, Representative Harnett. And so you and I have both practiced law, and I think that we, as a result of that, have this have dealt with circumstances where evidence was lost or destroyed or not accurately recorded. Can you please elaborate a little bit on your kind of long-standing concern about the preservation of evidence that gave rise to this bill?
I think that, it almost relates to some of the issues we were discussing on the bill prior to this morning. And the fact is that the criminal process, as can the civil process, but the criminal process in particular can take years and years with litigation and challenges even when a person is incarcerated. Knowing that witnesses die, evidence can be lost, having recorded interviews in some capacity on some platform can preserve perhaps the most important evidence in a case. So I think that it's just good practice. I think it protects both the prosecution and the state by being able to access those recordings at any time throughout the process. I'm not sure if that addresses your question entirely.
It does, and it led me to a follow-up question. So you were saying that LD 448 actually requires the adoption of a policy. And so does that give someone who's looking for evidence of a statement or trying to track down a statement, does the policy give them kind of a roadmap to follow so they know where to find that statement?
The policy would be developed by the Criminal Justice Academy, so I don't know what it exactly would look like. It might cover issues of, there were concerns raised in the chief executive's veto message that there are instances in which recording a witness interview might not be feasible or even practical or humane if you're talking to somebody who has just witnessed a very traumatic event and who might not want to talk about it if they know they're going to be on camera or recorded. So ideally what the policy would do, and this would be developed by the Criminal Justice Academy and its board, it would set out standards for when interviews might be required, but it would also set out policies about what summaries should look like. As I sort of compare it to watching a foreign movie with subtitles and you hear like 3 minutes of dialogue and then they put 2 words like thank you, and you realize that, well, I don't understand that language, but I thought they said a lot more than 2 words. And then it would also establish policies for the maintenance of those records in whatever form they exist. But I can't talk about a policy that doesn't exist yet.
Thank you. I guess the point I was asking you about is having that policy written, does that provide sort of standardization and certainty and an understandable system that everybody's following?
That would be my hope. These policies are then communicated to all law enforcement agencies throughout the state and are typically adopted verbatim by those agencies.
Thank you. Do other committee members have questions for the bill sponsor? I am not seeing any. Representative Harnett, thank you very much for presenting this bill today.
Thank you.
At this point, we will turn to those who wish to speak in support of this legislative measure. And I have two individuals who signed up ahead of time, Mr. McKee and Mr. Pelletier, who were with us for the previous bill hearing. And I'm going to bring them both into this meeting. And we'll start with you, Mr. McKee. You may proceed.
Thank you, Senator Carney, Representative Harnett, members of the committee. I'm Walt McKee. I'm here to speak on behalf of and in support of LD 448 for the Maine Association of Criminal Defense Lawyers. This is a bill, I'm sorry, I didn't, I just stepped on just a second as Representative Harnett was finishing. I don't want to repeat anything, but this is something that's been addressed with respect to suspects and involves establishing policies. It's important to recognize that this is just a bill to establish a policy that will be followed for law enforcement recording of witnesses. Having been involved in reviewing discovery in criminal cases, hundreds if not thousands of those, I think that everyone on all sides can appreciate the need to have accurate recorded information about what a witness says about what had happened. That's important because a law enforcement officer's recollection about what a witness said is all well and good, but it's not always the specific, detailed information that everyone in the system wants to have. It's especially important too, because there should be no issue one way or the other about what somebody said, about what they observed or heard or felt or had any kind of involvement in. It should simply be recorded. This issue actually came up almost maybe 10, 15 years ago before this committee. And I remember testifying about it. And I remember talking about the issue in terms of, what's the issue? What's this going to cost? How hard is this in the first place? This was before body cams and digital recording. And I actually mentioned at the time, and I think I even brought over a little tape recorder. And I said, you can go to the Kmart, back when Kmart was around, and record these, buy a tape recorder and record interviews. It's really simple to do that. And that way, nobody later on can say, well, that's not what I said. It would be simply recorded and very simple. Now it's even that much more simple to do this. But this bill doesn't say that law enforcement has to do it. They simply have to have a policy. And what's important about policies, Representative Harnett is correct. Policies are established, then sent down to law enforcement agencies, and they are established and put in policy verbatim, is that this is what you're going to do. And I think by and large, law enforcement agencies, with respect to suspect recording, they do follow that as a best practice. And as the years go by and these policies become more and more entrenched in law enforcement, they become what they do. And that's what this bill would do, was to start a process where there's recording of interviews. So there's no question about it. And it will be something that's done, as it can be very easily, for many years to come. So we support the bill, and hopefully it will go through this session, and a policy will be established. It will be inexpensive, but it will be good and fair. Thank you.
Thank you very much. Members of the committee, are there questions for Mr. McKee? Representative Babbage, go ahead.
Thank you very much, Madam Chair. Sure, I might as well ask the good Mr. McKee this question. What I'm looking for here is a better understanding of to whom we are asking this responsibility. In a murder case, the AG's office is going to be involved anyway, but we're still talking about municipal law enforcement establishing a policy before this might get to the AG's, jurisdiction. I just wondered about, is this a first step that may indeed develop a patchwork of policies that may later need to be addressed, or do you see this being much more confined as to whom is going to be responsible for developing these policies?
What happened when the bill passed with respect to suspect recording is that a policy was established and everybody followed it. And I know that because I didn't know what had happened. I was looking for this in a case one time, and I looked at different departments, and it was exactly the same. It was Augusta PD, Winthrop PD, and there were a few others. I realized, oh, wait a minute, they've just taken this all because they don't want to do this themselves. It's a good policy, one that's established with the help of the chiefs of police. They are part of that process in terms of the policy development. And so what ultimately comes down is something that can work for all departments in as simple a fashion as possible.
Thank you.
Are there any other questions for Mr. McKee? Not seeing any. Thank you very much for providing your statement today, Mr. McKee. The second person here today to speak in favor of this legislative measure is Mr. Pelletier. You may go ahead, Mr. Pelletier.
Thank you, Senator Carney, Representative Harnett, members of the committee, John Pelletier, Chair of the Criminal Law Advisory Commission. We are in favor of this provision. I'll say a little bit about the process, which has been discussed. So what in statute, there's a section of statute where there's about a dozen areas where the legislature has mandated criminal justice academy policy, model policy. When the Criminal Justice Academy, pursuant to the dictate of the legislature, promulgates a model policy, every law enforcement agency in Maine within the following year has to adopt a policy. And that policy has to meet the minimum standards of the model policy. So if policy is about recording, it can't be less stringent about recording than the model policy. And in effect, what Mr. McKee just said, the law enforcement agencies adopt the model policy, and they have to report back to the academy within a year. Here is the policy that we adopted on such and such a date. And so there's some enforcement there. And Mr. McKee is exactly right. Years ago, the legislature said you have to have a model policy on recording of suspects. I believe the original legislation said in serious cases. So the academy created a model policy, and it deals with things that, it has some definitions to clarify. It talks about what happens if the equipment doesn't work or it's not possible. So it provides flexibility for individual circumstances. And this policy with respect to suspects exists. I used to have a copy, I don't anymore, but it could be obtained, the model policy from the Criminal Justice Academy. And I suspect they will just modify that slightly to include suspects and witnesses. And one of the things we heard is from, for example, advocates for sexual assault victims, is that they may not want to be recorded. And the existing policy that I've seen addresses whether the subject of the interview can say, I don't want to be recorded, that sort of thing. So the academy looks at all the circumstances. They create a model policy that has flexibility and clarity in definitions, and then they require the law enforcement agencies to adopt at least that minimum policy. And that's what would happen here if the bill passed.
Thank you very much, Mr. Pelletier. That was helpful information. Are there any questions on the part of committee members? All right, I am not seeing any questions. Thank you for being here today. The next person who wishes to provide a statement in support of this measure is Jan Collins. And Jan, I am going to quickly move you onto the panel here, and you may proceed once you're on the panel. Welcome again.
Thank you. I appreciate it. And greetings, Senator Carney and Representative Harnett and honorable members of the Judiciary Committee. Again, my name is Jan Collins. I'm Assistant Director of Maine Prisoner Advocacy Coalition. And I just want to state up front before I go through my testimony that I am in favor of the process that we're approaching this with in terms of having a policy developed and sent to individual towns. But I'm also in support of the actual taping of interviews. I read a daily meditation today. I do every day, every morning. And today's meditation was a confirmation bias meditation by Father Richard Rohr. And he started with the quote, "Quid quid recipitur ad modum recipientis recipitur." I don't know Latin, so I had to get the translation. Whatever is received according to the manner of the receiver. What it means in words is that we don't see things as they are. We see things as we are. Its application to this bill is confirmed in a number of different studies on police interviewing techniques going back for decades. I have included a list of some of that research. There's much more. What we learn from this research is the manner of the interview can influence the veracity of the information gathered. Blind interview, in quotes, techniques lead to more accurate information than interviews with leading questions. The questions themselves can influence the answers, and the bias of the interviewer can influence the questions. Not only does the interview technique influence the quality of the information gathered, but the pieces of the interview that ultimately are transcribed are influenced by the person recording the information. This happens with the best intention of interviews. We bring ourselves to every situation. In order to capture all the factors influencing an interview and its outcome, a recording is necessary. Both visual and auditory would be best. In the US, freedom and justice are two of our highest values. In the interest of preserving both, I ask you to support LD 448, an act regarding recording of witness interviews. Thank you for your consideration.
Thank you very much. Are there any questions for Ms. Collins? I am not seeing any. Thank you once again for appearing today before the Judiciary Committee.
Thank you.
Next, we have listed as, well, first of all, let me just do a final call. Is there anybody present in the electronic meeting who wishes to testify in support of LD 448? I am not seeing anyone indicating that is the case. So in opposition, we have Sheriff Todd, Treasurer. Sheriff, you may, let's see, I'll move you into the committee. And once you're with us virtually, you may proceed.
Senator Carney, Representative Harnett, distinguished members of the Committee on Judiciary. My name is Todd Brackett. I'm the sheriff in Lincoln County. I don't know where Todd Treasurer comes from. Maybe that's because that's my title within the association right now, I guess.
Yeah, I'm sorry I gave you a new name, but that's what your virtual name is.
That's okay.
Thank you for giving us your real name.
That's okay. Madam Chair, procedurally, I would ask a question before I begin, because had I been standing in the committee room as we would traditionally and heard the clarification that Representative Harnett gave at the onset of this proceedings, I would not have submitted this testimony. So I would formally request that if it's possible, I don't know what procedurally, to remove the Maine Sheriff's Association from opposing this bill. I think Representative Harnett did an excellent job clarifying the intent of the bill, which was some of the confusion perhaps on our part when we went, and he also addressed the concerns that we have, which I think he shared from the chief executive's office in the veto process last time around, was simply regarding certain situations that can be very difficult to record. So I think with that having been said, I'd like to withdraw our testimony. I'm going to go out on a limb and suspect that once we have a chance to discuss it, that the sheriffs will be supportive of this initiative.
Thank you very much, Sheriff Brackett. And from a logistical, technological perspective, I don't know if it's possible to remove testimony that's been received from the legislative website. However, if you could please provide testimony that is labeled amended testimony. Then it will be clear from the label of the document that it is an updated version. And we do really appreciate you appearing here today to clarify, well, to hear our clarification from the legislative perspective and also to provide your updated status regarding the legislation. With that, I will just ask if there's any member of the committee who would like to ask any questions. And I am not seeing anybody. We will do a work session on this bill within the next week or so. And so if you could, Sheriff Brackett, provide your amended testimony within the week, we'd really appreciate that.
We'll be sure to do that. Thank you very much.
Thank you. Oh, Representative Harnett, did you have a question?
I just wanted to let Sheriff Brackett know that I will be in touch with them to discuss ways to make the statute work for all stakeholders.
Great, thank you.
All right, and then finally on this bill, is there anybody who is present in the electronic meeting who has not provided a testimony who would like to speak in favor, in opposition, or neither for nor against LD 448? And I am not seeing anyone indicating that they wish to provide a statement. So with that, we will close the public hearing on LD 448. At this point, we have about 50 minutes before we resume for our presentation this afternoon. This live stream will continue even though we sign off. So please, committee members, remember to mute your audio and turn off your video during the break so that nothing is inadvertently broadcast. And with that, we will see everybody back at 1 o'clock. Thank you very much.
How is the family, Sam?
Hanging in there. Thank you for asking.
That sounds like an honest answer.
Thank you, Sam, for the response. Appreciate it.
Morning, everyone. I mean, good afternoon. Time flies. We are just about ready with the members of the committee returning from our brief lunch break. We'll call the meeting to order in just a moment.
Senator Carney,
Yes.
I noticed that Ambassador Dana is in the attendee room. I didn't know.
My gosh, thank you. I
Be
will.
promoted. Thank you.
Up. Thanks, Tom.
You're welcome.
Representative Newell, I just wanted to let you know that Chief Dana is having trouble or doesn't have access to the link. If somebody could send that over to her.
I just sent that along by
Okay,
text
thank you.
and email.
Thank you, Chief. Peggy, if I might, Chief Dana is having trouble with her link. I know that I had sent a request to Susan about 15, 20 minutes ago, asking for the link to be resent.
Yep. And I know Chief Sabata sent it also, so we'll see what we can do.
Okay, thank you.
Soup, did you already send it?
It's been sent. Yes, it has.
Okay. If she's not finding it, sometimes it goes to a spam or a junk email folder. or if I don't know if she's not getting the email or if the link is just not working.
I've got my eye on the attendee
I
section.
believe she has come in as Chief Clarissa Sabatis. she's here. Thank you.
Woo! Big shoes to fill.
Would you mind if I change your name?
Yes, please.
Oh, I don't have authority to do that. Maybe,
I want royalties.
Yeah.
Peggy or Soupy might be able to change your name.
To get you. Fixed.
Tom, do you have a host status that you can, oh, here, we're all set. Thanks, Soupy. Good afternoon, everyone. It looks like we are ready to convene our afternoon meeting. This is the Maine Legislature Joint Committee on the Judiciary. And we have an information session and a meeting and greeting session this afternoon with tribal chiefs and Ambassador Dana. We will start this meeting the way we ordinarily start our meetings. Members of the committee will introduce ourselves to our guests. And then at that point, we'll ask our guests to introduce themselves, and then we'll begin our conversation. And typically I call on committee members to introduce themselves. And so I'm just going to start at the top of our list of representatives here with Representative Babbage. Chris, could you introduce yourself, please? And we're going to do just a little bit more of an introduction than we typically do. We typically give our names and our districts, but I think if all of us who are in the meeting can just say a little bit more about ourselves than just the numbers, which is what we're so used to, that would be really nice. So Representative Babbage, go ahead.
Thank you, Madam Chair. It's highly unusual for me to be recognized and asked to please elaborate a little more than normal. Welcome, everyone, and to our guests. My name is Christopher Babbage. I have the good fortune to represent House District 8, which is most of the town of Kennebunk. This is my second tour in the legislature. I served 2 terms, left for 6 years, and then have returned, and I'm in my 4th term currently. I have served on energy and utilities, on natural resources and the environment. The environment has always been important to me, and then state and local government regarding constitutional issues, which has been important to me, and then of course the human rights issues that come before us here on judiciary. I'm a 40-year high school teacher, retired, and obviously we've been immersed in the MITSIC and tribal sovereignty issues especially over the 129th. And I actually have 2 bills in this term that I sponsored that extend the deadlines for access to a purchase of land and recognizing legal jurisdictional for the tribes. legal jurisdictions. And then I also have another one that is a monetary bill saying that as long as the state has casinos and that the
Representative Babbage, I'm sorry to interrupt you, but we're not joined. Yeah, talk about specific legislation. It's more of kind of like a personal introduction.
okay.
Thank
And
you
so,
very
so the
much.
last one was just something that will be of interest to the tribes because it would expand their financial situation. Thank you very much, Madam Chair.
You're welcome. Representative Reckitt, do you want to give a brief introduction?
Inspired by Representative Babbage, yes. My name is Lois Reckitt, and I represent the ocean end of South Portland, which is District 31. I think the things that would be interesting for you to know about me is that I'm by training a marine biologist. That's what my education was in. But I have been a somewhat rabid and self-acknowledged feminist since 1971 and have been active in the women's movement for all that time. The three things I want to quickly say is that I was happy 4 or 5 years ago to start working with Judge Maynard on the bill that eventually passed last year on violence against women and the tribal jurisdiction. I was thrilled to see that happen. I also spent some time on the national board of the National Coalition Against Domestic Violence, including a term or two as the national president. And that organization has been committed for its entire lifetime of honoring Native people at its annual conference and as a mandatory membership on its board of directors. And I also, as I mentioned this morning, was heavily involved in a pardon case for a Native woman in, I believe she was the Penobscot, who had been had been convicted of murdering her father. And we did manage to get Governor Baldacci to pardon her eventually, and I was thrilled about that, worked on it for about 5 years. So I'll leave it there, but I was glad last year to be able to travel to some of the reservations and tribal areas that I had not yet been to, and I hope all of us have more opportunity to do that when the world opens again. Thank you.
Thanks, Representative Reckitt. Representative Moriarty?
Thank you, Madam Chair. I'm Steve Moriarty. I've lived in my hometown of Cumberland for 37.5 years now. I've lived in Maine since I was 3, grew up, went to school here, college, high school, law school. I'm a retired attorney. My background in terms of public policy and things like that for many years was on the town council, also on my town planning board. Served in the 126th from 2012 to 2014 on judiciary, returned to the legislature in June of 2019, had a brief tenure on the Innovation Development Committee, but that was cut short by the pandemic. So pleased to be back on judiciary and pleased to be getting up to speed on many of the sovereignty-related issues.
Thank you very much, Representative Moriarty. Representative Sheehan?
Thanks, Madam Chair, and good afternoon, everyone. Honored to see you all again. My name is Erin Sheehan, and I represent House District 12. So that is the downtown part of Biddeford. It's my first time running for office, first term on the Judiciary Committee. And yeah, I mean, I've been in Maine for 4 years. I grew up in Eastern Connecticut, spent a lot of time in Vancouver, BC, Seattle, Washington, New York City, Dallas, Texas, but had been dreaming of settling in Maine for probably about 15 years. until I finally decided to make the move. So I'm thrilled and honored to be here and looking forward to this conversation.
Thanks, Representative Sheehan. Representative Downs?
Good afternoon. Thank you, Madam Chair. I'm Kathy Downs, and I am from District 130, which is Bucksport and Orrington. I live in Bucksport. I was a Bucksport Town Clerk for 27 years, retiring in April of 2019. And I have since then became a Town Council member. And I'm on numerous committees that goes along with that. I'm also on the State and Local Government Committee, along with the Judiciary Committee. And I think that covers it pretty much. And I'm glad to be here. Thank you.
Thanks, Representative Downs. Representative Evangelos?
Thank you, Madam Chair, and welcome to see our First Nations. This is my 4th term in the legislature, not consecutive. I took 2 years off. In the late 1960s, I was a civil rights activist and anti-war activist. I obtained my graduate degree in Orono in the early 1970s, and my first job was in Northeast Washington County in the early 1970s. And I witnessed the poor housing and the poor water, the racism, and the lack of economic opportunity. And as they say, the rest was history. Welcome, everybody.
Thank you, Representative Evangelos. Peggy, would you like to do an introduction?
Hello, I'm Peggy Reinsch. I'm one of the analysts that works for the Judiciary Committee. I'm in the Office of Policy and Legal Analysis. I've been in the office a very, very long time, and I've been working with the Judiciary Committee almost as long.
Thank you. And Sam?
I'm the other analyst, and I have been at OPLA a far shorter period than Peggy. My background is as an attorney and in public health. I'm glad to be here.
Thank you. Supi, would you like to do an introduction?
Hi, welcome everybody. I'm Susan Panett, or Supi is my nickname, and I have been with the Judiciary Committee. Actually, this is the start of my 32nd session, and I'm thrilled to be here. It's nice to see a lot of the new faces, and thank you for this opportunity.
Thank you. I'm Ann Carney. I'm a state senator. I previously served 1 term in the House of Representatives. I'm an attorney. I had a practice that focused on municipal, civil rights, and employment law, and then spent 8 years volunteering with Pine Tree Legal Assistance, representing Mainers all over the state. I'm the proud parent of 3 adult children. I also love to cook. I'm getting a little more personal, I think, than others. I was served on the Labor and Housing Committee when I was in the House of Representatives. I'm very thrilled to have made the switch to the Judiciary Committee because I am so interested in and excited to work on our sovereignty legislation. And I am very glad that you all accepted the invitation to come today. Thank you for being here. And Representative Newell, would you like to introduce yourself? I apologize for not calling on you in our usual order.
Thank you, Madam Chair. Welcome to all the chiefs in attendance. I am Rena Newell, the Passamaquoddy Tribal Representative, representing Indian Township and Sabayak. And I think I could say that I have worked within tribal government for almost 35 years. First coming in to a position within our finance department, and then switching over to program management, where I was the tribal education director for higher education. This is the 3rd of my 4th year serving as the tribal representative. And during the 129th, I sat on the IDEA committee. And now here I sit on the Judiciary Committee. Thank you so much.
Thank you very much, Representative Newell. And I just have to ask Representative Harnett, because I don't know where my mind is today. I'm in a very windy room and the wind is kind of whistling in one ear and out the other. Representative Harnett, did I give you an opportunity to introduce yourself?
No, but I'm over it now, Madam Chair.
I'm sorry. Go ahead.
It's okay. Good afternoon and welcome to our guests. Very much looking forward to this afternoon. My name is Tom Harnett. I represent House District 83, which is the city of Gardner where I live, and the town of Farmingdale. This is my second term as a state legislator. I served on judiciary in my first term, and prior to that, I served as the mayor of Gardner for 6 years. I am a lawyer by trade, born and raised in New York. I was born in the Bronx. The first 9 years of my legal career, I worked for migrant farm workers in the Hudson Valley of New York, and then moved to Maine in 1989, where I worked in the Office of the Attorney General for 27 years. While I did environmental work the first decade, I also had the privilege in the early 1990s and mid-90s of staffing MITSIC, the Maine Indian Tribal State Commission, and through that, I was lucky enough to visit all of the tribal lands and reservations in the state and got to make some really nice relationships, and also learned a lot about the history that I was never taught and experiences that I never thought I would have. I then did civil rights work in schools, went around to schools throughout Maine to try to stop bias-based behavior, and was able to go to some of the schools on reservation land and surrounding communities. So the issues that we're going to be talking about this session and that we talked about last session are very important to me, and I look forward to learning more today and moving forward. So again, thank you for being here.
Thank you, Tom. And at this point, I would like to call on our guests to introduce themselves. I can follow my list, or if there is a preferred order that you would like me to follow, or I can do that as well. I'd love a little guidance.
I think your list is fine.
Thank you. Okay, well, you happen to be at the top of it. Chief Sabatis, would you like to introduce yourself?
Shoot, if I had known. No.
Then it's not okay. Yeah.
Look, he talks too much. No, it's nice to see some familiar faces this year, and some new faces. And I'm Clarissa Sabatis. I'm the chief of the Halton Bantamousie Indians, for those of you that I haven't had the opportunity of meeting yet. I'm a registered nurse by trade, so this is very far from anything that I had anticipated earlier on in life. And I worked most of my life in healthcare. And I think the last 6 years before I became chief, I worked in public health, 6 or 8 years, I guess, specifically as part of a team building our tribal Wabanaki public health infrastructure. I had different roles throughout that, as well as doing a little bit of nursing here at the local hospital. I had anticipated being an ER nurse when I was a little younger, but so this is a little far from what my plans were, but I definitely am enjoying my time right now. I'm coming to the end of my first 4-year term, and my experience in tribal government before that was 2 years on tribal council. So I'm a newbie. I guess that's all. And thank you for the opportunity. I think this is, I really appreciate the time that we're spending here to just get to know each other a little bit.
Thank you and welcome. Chief Maggie Dana, you are next, if you'd like to introduce yourself.
Good afternoon, everybody. My name is Maggie Dana, also known as Elizabeth Dana. I'm the chief of the Passamaquoddy tribe at Sebayig, which is Pleasant Point. 2 tribes, 1 tribe, 2 locations. I think my background is mostly in finance. I've been there 17, 18 years. I have a son. I've been vice chief for about 4 years. I'm a new chief. I have been on council and various community groups. And that's about it. I think when the Settlement Act, when this was passed, I was probably about 7 years old. So I remember some of the before and how things changed. And I think I'll just end it with that. I look forward to working with you all and meeting the new people on the committee. And that's all for now. Thank you.
Thank you very much and welcome. Chief Francis, you're next. Would you like to introduce yourself?
Sure. Good afternoon, everyone. Thank you, Senator, Representative Harnett. I've realized that if my head's sit in a certain way, it looks like I have horns, which some people would find appropriate probably, but I've been reminding my friends are texting me now, getting a big kick out of that. So I have to find a different camera angle, but I've proudly served as the tribal chief at Penobscot Indian Nation for 15 years now, serving 3 terms on the tribal council before that, and grew up, born and raised on the Penobscot Indian Reservation. Through all of the challenges that we talk about in this process, it was an amazing place to live, raised by extraordinary people, and I think it's made me who I am today. And I'm really proud to, in a self-gratifying way, to still be working for that community. So I just appreciate being here today. Representative Sheen, welcome to the state of Maine. I also had the pleasure of living for 9 years in Norwich, Connecticut, and working for my good friends at Mashantucket Pequot and Mohegan Sun. And so what a beautiful area that is as well. With that, I look forward to the conversation today. Getting some perspective, maybe some refreshers on kind of how we got here, what the effects have been on the tribes, and working towards the solutions that were laid out in the legislative resolve in the 129th. So thank you all.
Thank you very much. Ambassador Dana, would you like to do an introduction?
Certainly. Chief Francis, I didn't even notice the antlers until you said something. I'm so disappointed in myself. Good afternoon, everybody. Thanks for this meeting and for having us here. My name is Mully and Dana, and I serve as the Penobscot Nation Tribal Ambassador. And the ambassador role came about because we had removed our tribal representative, and my role is kind of filling that place without sitting in the chamber and committees, but having a voice and a face around Augusta and beyond. I've been appointed twice by Chief Francis, so it's all his fault. Prior to that, I was elected to tribal council, and prior to that, I was a very grumpy political science major in a human resources career that I didn't enjoy, and a single mom of 2 very young children. So I've been very blessed and honored and happy to be able to do this work. And I look forward to this new session. Like the chiefs have said, it's really great to see some old faces. And I think we're all really looking forward to making new connections and hopefully advancing some really meaningful change around tribal sovereignty and self-determination. Thank you.
Thank you very much. Let's see, at this point, I think what committee members would very much appreciate is we would like to listen to anything that you would like to tell us. We don't have specific legislation in front of us, and so this isn't kind of a hearing on a bill that we anticipate we'll get, but it is an opportunity for shared information and building relationships. And we would very much like to hear any information that you would like to tell us. And I hope it's appropriate for me to just open the floor up to you at this point. And feel free to, of course, ask us questions as we go along. And is that a good way to proceed? I see nodding antlers. That sounds great. Let's go ahead. I am going to turn off my mic and just, who should I recognize first to lead the conversation?
I think the antlers should go first.
See, I shouldn't have said anything.
Yeah, you've been nominated. Go ahead.
Well, again, I appreciate the opportunity to talk on this again. I think we're going on 3 years now, some of us in this process, and I just thought maybe it would be appropriate to kind of briefly go over, kind of how we got here in terms of the task force, also the the legislative history and legal history that's rooted in, and why this is so unique in terms of getting outside of our thought process around a just basic everyday ordinary statute and legislative process, with a responsibility, quite frankly, that the state has in this committee in particular in dealing with tribal sovereignty, tribal self-determination, and a tribal state relationship, which is not typical of most states. And I appreciate the complexity of that at times. But the legislature in the 129th, the tribes had been, I'll speak for Penobscot, for 8 years. We basically had no meaningful conversations with the state of Maine leading up to 2019. We came off a very sad time of not having a legislative representative in the Maine state legislature after 200 years, and things were really falling apart, and it was a very fractured relationship. So we were going about our business again for close to a decade. When there were people that were committed to trying to figure out solutions and try to recognize the importance of a productive tribal state relationship and what that meant for all Maine citizens. And I think everybody kind of came to the table in that spirit. And I mean, so initially, House Speaker Gideon, Senate President Jackson reached out to the tribes and wanted to have a meeting. The tribal chiefs accepted that meeting. And again, I'll speak for myself and not them, but I can tell you from our perspective, we were extremely skeptical of this conversation initially. But as the conversation started to go on, and I think that's an important point to really highlight, is that the tribes didn't put in legislation to try to address these things. We didn't pursue these things. This was really a legislative invite to participate in an effort to improve this and give us a voice in how that should be improved. So in that spirit, we met with them in April of 2019. The chiefs immediately started to meet and pool their resources, from attorneys to consultants to experts to historical people, and really have spent a lot of human and monetary resources over the past 2 or 3 years in this effort. And one of the really nice things about it is, I think our relationships as tribal leaders has really grown together over the past couple of years. We've spent an enormous amount of time together. We've, for the first time, really started to discuss, and it really gave us a venue to discuss a lot of issues, not just this. So I've been thankful for that. On May 9th, almost, just a few weeks later, the chiefs were able to reach consensus on what the approach should be. And the approach really was to be in line with the legislative resolve. And the legislative resolve really talked about getting the tribes of Maine to the same rights, privileges, immunities as any other federally recognized tribe in the state. And this wasn't, and we all had an understanding that this wasn't about really giving the tribes anything or enhancing the tribe status. It was about a restoration effort that we're seeing all over Indian country in the United States in the self-determining era, which has been going on longer than the Settlement Act. So, and I'll get to why the evidence of the task force really pointed to that restoration line of thinking. So we established three priorities to that the laws of the state would not apply within Indian country, except as provided and agreed to by this process and between the state and the tribes, or provided by federal law. We agreed to amendments to confirm that the tribes shall, again, live up to the legislative resolve in the goal and objective here, and that was to restore the same rights, powers, and privileges and immunities of all federally recognized tribes, and to confirm that acts of Congress, and we'll get into that, I'm sure, that are enacted for the benefit of Indian country apply in Maine as agreed to by this process. And so so the task force recommendations largely accomplished that goal. And as you all know, most all of those recommendations were voted out of committee the last session. And of course, the pandemic hit and things got put on pause. So here we are. And so in the larger historical context, though, I think is also important. And I want to briefly just talk about some of those facts that are often kind of misunderstood or ignored. The 1980 Settlement Act is a modern day treaty between sovereigns and the indigenous tribal nations of Maine, of course, who have resided here since time immemorial in the state of Maine. The very opening words of the act state that is intended to memorialize an agreement between the tribes and the state of Maine. And as a treaty, we've all recognized it through this process that it's a living document and that it's open to change. And we're glad that the legislature sees it that way. That approach is evidenced in multiple ways, including the United States Congress, who under the Constitution is the only entity that has plenary authority over Indian tribes, has basically said, to the extent the tribes in the state can agree, it is legal for them to make changes to this document. So, in the Supreme Court, and we've been through all of this, and I know a lot of this is redundant for some of you, but the Supreme Court long ago established that states generally have no authority over tribal nations and their lands. And the only way they get that authority is, again, through Congress. So there's tons of history around, and legislative and legal history around the sovereign status of tribes. And so, the land claims put a cloud over about 2/3 of the state of Maine. And the reason that happened, and I think what people often forget in this whole thing, they think life began in 1980 for the tribes of Maine, and which is obviously not the case. The 1970s brought a lot of clarity and legal victories for the tribes in establishing who exactly we were. The Bottomley versus Passamaquoddy case, for example, where the First Circuit ruled that the Passamaquoddy tribe retained its inherent sovereign powers, and in that case, sovereign immunity from suit. State versus Dana was another Passamaquoddy reservation case that basically criminal jurisdiction over alleged crime that was happening there didn't rest with the state of Maine; it rested with the United States. And so, all of these cases had tremendous impacts on all the tribes. And so, so there was a legal foundation that basically recognized the tribes of Maine as federally recognized tribes with all of those immunities and powers. So we had those, and that's years before the Settlement Act. So, I'm sorry, I'm a little lost here. Okay, here we go. So basically what the task force was trying to do was amend the government-to-government relationship between the tribes and Maine. And based on the Settlement Act was really based on the Non-Intercourse Act, which meant the tribes had ceded significant portions of their land to the state of Massachusetts and later Maine That was the whole premise of the land claims, was the Non-Intercourse Act was violated and those treaties were illegal. Those land secessions were illegal. So it created this cloud over 2/3 of the state of Maine. The task force recommendations for amending MIA try to correct these failings from the Settlement Act. It really tries to modernize and get the tribes to where most tribes are in this country. So we have a real strong legal and legislative foundation to say that this is truly a restoration of self-determination for the Maine tribes. It's led to countless litigations. It's led beyond litigation. The tribes of Maine have been left out of some 150 federal beneficial acts passed by Congress, from everything which we partially corrected in the Violence Against Women Act to Tribal Law and Order Act to be able to address such crises like opioid addiction and other based things in our court systems, to FEMA-based provisions in the Stafford Act that would allow the tribes to declare disaster declarations within its own territory, and of course the always popular Indian Gaming Regulatory Act. And I think what people really fail to understand about IGRA, we get caught up in casinos and who gets to have them, but IGRA has a significant history, legislative history and study behind it that really, it's called the Indian Gaming Regulatory Act. It should be called really the State Gaming Regulatory Act, because the Cabazon decision in the Supreme Court basically said that carte blanche tribes can do gaming as part of their inherent sovereign right to economically develop. And of course, Congress fixed that to allow states to have some say in those things. So the Indian Gaming Regulatory Act is really about states and tribes collaborating, and also defines gaming in terms of Indian tribes in a much, much different way than it does with commercial gaming. So Indian gaming is a function of tribal government with all its benefits and proceeds going to governmental services. And so that is, I think, a huge misunderstanding when we have the conversation around gaming. This, again, was a study on an impoverished, disadvantaged population that they realized there was a mechanism for Indian tribes to overcome that and parlay that into other areas. And most of these tribes with those revenues have become major players in their regions, libraries and hospitals and increased tax payments and all of those things. And those compacts have been fruitful for both sides. So that's a function of a sovereign tribal government that is a revenue generator for governmental purposes. And not to get bogged down in that, but that's been one of the most glaring examples of some of the inequities over the years. But beyond that, the tribes of Maine are still dealing with health disparities, economic disparities that far dwarf the average Maine community or Maine citizen. We're dealing with over 20% diabetes rates in our community, high rates of cancer, hypertension, infant mortality, and average age of death is still in the late 50s among Maine tribes. So there's a whole, and these things can't be cured really in a silo. So these changes that some consider sweeping are important because comprehensively they have to be addressed. There's an economic tie to it. There's a healthcare tie to it. There's an educational outcome tied to it. There's all kinds of things that have been suppressed by this relationship over the years that have caused the Maine tribes, in some cases, to stay in the 1980s. And we've been through this ad nauseum with the work group. But I think it's important that, and I think we all understand in this with this land claim settlement that all of the discomfort around this relationship and all the strife and the legal problems and all of that have simply stemmed from ambiguities and people's understandings of this, and quite frankly, we get bogged down in who gets to control what most of the time, and we're not really looking at the conditions and what the potential outcomes are and what the tools could be to make things better. And so, and I certainly appreciate and understand the difficulties of governing, and been doing it for close to 3 decades. A lot goes into making decisions legislatively and lawmaking and all of that stuff that sometimes doesn't always come down to what's right and wrong. But I think in this situation, when we're dealing with a responsibility as high as this one, in terms of a government to government relationship, if that responsibility is going to be taken on by the state, just like the United States Senate on Indian Affairs, the U.S. House of Representatives, House Natural Resource Committee, those entities are structurally dedicated, not always perfect, obviously, but they're structured to deal with this at a very high level, and that thinking goes beyond the normal legislative process. So I hope we can get there to understand that this isn't about taking away from anybody or giving anything to anyone. It's about a proper recognition about the tribal nations in the state of Maine, where we all want the same things, health and prosperity and success for our communities, families, regions, and state that we're all part of. We're all state citizens as well, and want what's best for everyone. But at the same time, we cannot ignore the condition that this Settlement Act has continually perpetuated the Maine tribes in. And we just got to find a path forward in this modernization. And I think the recommendations of the 129th were proper. And I think we would have found that this state would grow significantly under that type of paradigm, and our relationship would as well. So with that, I'm just going to be quiet for a bit and hopefully, stick around, and I'm happy to answer any questions and about anything I've mentioned or anything I can be helpful in just creating some guidance here. Thank you.
I'll jump in, and I apologize. I may have to pause for a minute. Everybody's just getting home from school right now, so it's a little busy right here. Thank you, Chief Francis. I think he definitely did a good job of going over, the most recent history around this task force and the resolve that was created and the work that took place with all the tribal leaders. So I appreciate that. And I think I might start just by giving a little context with regards to at least the Holton Band and our involvement with the land claim settlement in 1980. I think, the Non-Intercourse Act didn't necessarily apply to us like it had to them. We had never entered into treaties or given up or ceded any land. We, in earlier 1980, after, a lot of negotiations had been taking place, the president of Aroostook Association of Indians submitted a letter to the Department of Interior, and he highlighted the reasons why we were considering joining this, but with some hesitation. He had discussed how we didn't want to jump in the middle and create confusion when there had already been negotiations taking place, and at that point we didn't have federal recognition, and our resources were pretty limited, so we were not able to even retain an attorney at that point. So getting involved was a little difficult, but I think that despite that, there had been a proposal by the current governor, I think it was Governor Brennan, to cut the fiscal year funding for Indian programs in Maine for 81, so after the Settlement Act. And for us at that point, I think between Micmac and Maliseet, Aroostook Association of Indians really relied on that. We received funding around education and the waiver for college and at that point there was a Maine, oh, what was it called? The Office, Department of Indian Affairs, I think. But we, this proposal really placed us under a little more duress and put us in a position where we felt like we had no choice but to become involved. We were worried about protecting our rights, and or even chipping away or having them reduced by not being part of this. And you know, after, I guess I'll go back a little bit further. You know, the tribes have not been dependent on funding for thousands of years. This is a new thing that came about with colonization, as I'm sure you're aware. But you know, in Aroostook County, I think it was a little later on. So I think it was the late 1800s where we really saw the logging industry pick up here, and a lot of our people experienced the loss of our traditional ways and were forced into a cash economy. So looking back, I see that agricultural work and basket making were the primary means to earning wages. And you know, at that point, I think our life expectancy was 46, 47. We haven't gone much further beyond that. Right now, I think for men it's 54 and women it's around 57. Our per capita income was around $900 a year. So at that point, really, we were experiencing discrimination and racism, not just from individuals, but it's documented from the state and local institutions. So I think the only path forward at that point was to support sovereignty and self-determination and look at federal recognition. So I think I'm trying to think of anything that he hasn't covered yet. Chief Francis always does a really good job. You know, I feel that for the most part, we all have similar situations. Even now, we've been able to build robust infrastructures that serve our communities and our nations, I should say. And, you know, we're growing, but despite the Restrictive Settlement Act, I think that for me, the thing that I would like is for people to understand or even put themselves in our shoes. So the dispute over this land should never have resulted in the federal government's forfeiture of any portion of their trust responsibility. At least that's how I see it. And it shouldn't have compromised any rights to self-governance. It equates to the US Congress giving New Hampshire Maine's sovereignty, or giving their sovereignty away to New Hampshire. So I think about our health centers. We're funded at about 50% of our need. How would Maine do if their tax base was sent to New Hampshire? All of their tax base just sent to New Hampshire, and they had no access to that when they're funded programs that are funded at about half of their need. And what if Maine administration and you as legislators were bound by restrictive laws that you had no authority to change? Even though you have your own government, you had to get permission, you know, to function under your own jurisdiction. It's frustrating. And I appreciate that we're here now. You know, I think it's 40 years in the making. And I really appreciate the relationships that we've been able to build, and the understanding and the trust that's been built over the last 3 years, I guess, almost 3 years. I think that the tribes being able to truly act as sovereigns and function under own self-determination can only be a benefit to the state. I think about where we are. I mean, there are 4 out of 5 of our tribes that lie within the 2 counties in Maine that usually are either 15th or 16th, as far as socioeconomic status goes. We could be doing so much here, even all of us could be. And this is the barrier. So, I apologize if all of you have heard this before, or I'm reiterating what others have said. I think that there is definitely a path forward. And as Chief Francis said, the intent of this, or at least that was the understanding, that this would be a living document and we could come to the table together and make changes that really worked, and changes that benefit the tribes despite the concern of unintended consequences. I think that I feel like that's a cop-out. I apologize. I think that's all I have for now. I tried not to be all doom and gloom today, but I really do appreciate the people at the table. I appreciate all of the work that's taken place to this point. I have been so hopeful. I know when COVID hit, it definitely was kind of let all the air out of my of everything. I really felt like we had some movement in a good direction, and that stalling that took place with COVID was tough to deal with, but I'm confident that we can get back to where we were. So thank you.
Thank you very much. Chief Dana, did you want to speak as well?
Yes, I didn't know what kind of forum we were going to do this in today, and I kind of took some stuff that I've talked about in the past. It's not long.
Am I frozen?
Oh, I think you have. Can you hear me?
Yes, I think my computer froze. I apologize. Go ahead.
Okay, so I'm just gonna, this is something that I've spoke about before, and I'm just gonna kind of go through and, it was almost like a speech, so try not to make it sound like that, but this is Wabanaki territory that we stand on. We will, we recognize this territory as our homeland, and we always will. We've fished these waterways and protected this land for more than 11,000 years. The Wabanaki people are resilient. We have survived despite displacement, sickness, poverty, trauma, and war. We've survived, but we've paid a severe price for it over many, many generations. Our 1794 treaty, which recognized the Maine's Constitution, identified specific lands where the tribe could reside on both fresh and salt water. These lands are mostly located at Zibayig, Pleasant Point, where I'm located, and Madocmigug, which is Indian Township. They're the freshwater tribe, we call them. These lands were reserved for many reasons. They were mostly reserved because they were allowed tribal members to continue to practice a sustenance lifestyle on the land. And this land supported living, hunting, fishing, traveling on the St. Croix watershed. And that's near the Calais area, and different reasons for different types of fishing game. Today, though, our lands and resources have been strangled by the Settlement Act. Some of our land, like the Zibayig Reservation, has been poisoned by the water supply that we've been given. This is all happening while the Settlement Act makes our ability to get clean water reliant on local politics. We want to change this dynamic. So communication and collaboration are prioritized over tribal state fighting and lawsuits. Communication is the key to all good relationships. The tribe and the state have not communicated well over the years. And Some thought that the Settlement Act would bring a brighter day for tribal and state relations, but we were wrong. Let's see, we are here, sorry, because we seek equality with other tribes in the United States. Today presents an opportunity to work, to change history, and to improve the settlement. It's an opportunity to bring the local economic development, improve public safety, and government-to-government communication that Maine's tribal-state relationship has needed for decades. Equality will enable us to bring new federal and private investments into Maine, to spur business and to expand government services, not just on tribal lands, but in our neighboring communities. We don't carry these fights on just for ourselves. It's about our neighbors too. For example, the effort that we carry on to improve the water at Zibayig would also directly benefit the Down East communities of Eastport and Perry. What could be wrong with that? What we proposed in the last legislature and plan to work with you all is grounded in building stronger communities. We are here as sovereign allies and ancient stewards of the land, seeking a better way to serve our community as Maine and a whole. We deserve to have a positive working relationship with our neighbors and with the state of Maine, but this will take work. I am here because of my tribe continued willingness to do the hard work and to work on these hard issues. It's just, I'm kind of going off script now and just speaking from the heart is, we just want to flourish. We want to be equal. We want, some people see us as we want handouts. We don't, we just want to be who we are, without restrictions. Other states have good relationships with the native nations within them, and Maine just really needs to catch up, that I really wish we could do some good things together that, that could be, that we're both proud of. I feel like we're so behind and it's frustrating. I've lost hope, and I haven't even been in this fight as long as, Chief Francis. I really thank those that keep coming back year after year after year. And I was a part of the last session, and I, recognize some people that are still on the committee, and that didn't work. We were almost there, and then having to have the bill broken up and compromise, and that's just tough for our people to be what we've been through, and to always I don't know what the word is, but it's funny that we just talk about being equal, equality. And I hope none of you have to want that in any way. There's these equal, we call them rights, but along with those rights come responsibilities. And there's a lot more to it, that when we in these lands, we have to take care of the lands. There's a lot of things to it, and it's not just all about money. There's spiritual aspects to it, and just being good stewards. Anyways, I don't want to keep going on and on, but I just hope that, again, there's that word hope, that we can do something good. And thank you all for listening.
Thank you very much, Chief Dana. Ambassador Dana, did you want to speak as well? Thanks.
Sure, thank you. So the chiefs did a really wonderful job of laying out exactly how we got here, and a lot of the movement over the past 40 years and even before that. And I wasn't yet born in 1980. So my whole life has been under the Settlement Act. So and I've had some really formative experiences as a teenager where I started to form, what tribal sovereignty meant to me. And my father, Barry Dana, was serving as chief at a time when the paper mill industry, was running very successfully. And this was in the early 2000s. There was a big court battle between the Penobscot Nation and these paper mills. They were seeking to get internal tribal documents. And long story short, the Penobscot Nation and Passamaquoddy tribe lost really hard. And at one point, 3 tribal chiefs were sentenced to not only jail time, but $1,000 fine each day that those documents weren't turned over to the paper companies. So I remember, and Chief Francis may have been on council when this happened, but I remember there was a big tri-council meeting with our tribe and the Passamaquoddy Joint Tribal Council. And it was decided that the tribes couldn't be without the chiefs, couldn't afford these fines. So instead of sending the chiefs to jail, they turned over the documents. And they did so in kind of a protest march, I should say, we did so. And the march started in Norridgewock, which is the site of a massacre in the 1700s of our ancestors who lived on the Kennebec River. And there was a French priest living amongst the people, and the British wanted to capture that priest, and they did so. They also slaughtered the entire village of Norridgewock people. And the people that did escape went across the Kennebec River and made their way into the modern territories of the Penobscot and Passamaquoddy and Maliseet and other tribes as well. So the march started at that place and ended in Augusta. And I remember, there was drumming and chanting and marching and holding signs, and I was there, and all of the signs said this was a march for sovereignty. But I remember thinking, this doesn't feel very sovereign to have to hand these things over and to have to give the paper companies our tribal council meeting minutes, our Department of Natural Resources information. So, the main reason we were losing so hard is that the Settlement Act was being interpreted in a way that treated us like municipalities, totally undermined our sovereignty, totally stripped us of our rights to self-governance. So as a teenager, that started to craft how I thought about sovereignty. And while I saw us not being able to fully act sovereign, I saw us as a people that viewed sovereignty as something very sacred and something to protect and something that we were constantly battling over. And in the years since, under Chief Francis's leadership, we have been in more litigation over the health and quality of our river. And the Settlement Act has been used time and time again to oppress us and keep us down. And you've heard the chiefs go into great detail about those specifics. So kind of fast forward to today, and in my work in this role, I also was recently elected to co-chair the Permanent Commission on Indigenous, Racial, and Maine Tribal Populations. And in that group, I'm really excited about that work because we are looking at Maine policymaking and the 3 branches of government in Maine through a lens of equity. And I know some of you are part of our exercise over the summer where we had subcommittees of lawmakers that our job was to look at all the bills that may go into a special session. Now, even though we didn't enter that special session, we got to sit with representatives and senators and look at a large number of bills through a lens of racial equity. So when I look at tribal sovereignty work, the bill last session ended up being one of the top priorities of that commission. And these things are all connected. You really can't separate the equity of all people of Maine from acknowledging the inherent tribal sovereignty of tribal nations in Maine. So I've kind of taken you on my little journey of how I've, come to understand sovereignty and where we're at now. And I am as well hopeful, like the other chiefs. I think looking at the process last session of the Violence Against Women Act bill, where we started and where we ended up was, a testament to connecting around shared humanity, seeing a problem, seeing solutions, and working really hard to get there. So I'm also optimistic that we can work that same kind of magic this time around. Thank you.
Thank you very much, Ambassador Dana. I have kind of two ideas about where we could go right now. One would be, I think all of us would really like to know what your top priorities are, but I also want to give you a chance to kind of ask us questions, kind of probe where we are on some of the things that you've raised. And then I know that committee members may also have questions. So I guess first I'll ask if, first I'll recognize co-chair Tom Harnett, who's always full of wisdom. Go ahead, Tom.
I'm not sure about full of wisdom, but Vice Chief Richard Sillaboy is in the attendee room. I didn't know if he wanted to come in and have the opportunity to address the committee.
I did not realize that was the case. I hope he hasn't been in there long. Vice Chief Sillaboy, I'm sorry that you were in the attendee space instead of the panelist space. Would you like to speak with the committee?
No, not at this time. Thank you.
All right, thank you and welcome. Tom, did you have a suggestion about how to proceed?
Not at this point, no, I'm sorry. I was focused on that and I didn't even listen to your suggestion, I must admit. So maybe if I hear it again.
I guess first I'll ask the chiefs and Ambassador Dana and Vice Chief Sillaboy if you have any specific questions or anything that you'd like us to address. That might be a great next step.
Well, Senator, just real quick, I think for me in this process, and I've been through two of these now, the Tribal State Work Group back in 2008, where there was a comprehensive report written. We based a lot of that, and what was nice about that process was there were actually a lot of participants that actually negotiated the 1980 Settlement Act. And so there's a lot of great information in that report. If folks haven't seen it, the At Loggerhead report in the late 90s was another one that was a comprehensive study on the same issues we're discussing today. So the Mitzick Suffolk University report, for example. So there's a whole, on top of what some are calling one of the most comprehensive task force reports that the legislature has seen recently. So there's a lot of information out there. And I think I would just, the tribes are constantly in all those processes, in my experience, the tribes are asked two questions. What do you want? Why do you need it? And we really, I think, have to, and I think that's fair to have that conversation. But I think that the bottom line is we have to just stay focused on really what the core foundational rights are of the tribes, what they've always been, when they were taken away, and how do we restore those, which was the goal of the legislative resolve. We can, as you know, legislating and as I'm well aware of in my own career here, there's a million ways to get to both answers. You can get the yes a lot of ways, you can get the no a lot of ways, and we can what if things to death. I've heard everything from what if you open a nuclear power plant on your land, or what if you participate in this irresponsible mining practices, what if you do the tribes, and then we're coming back showing you our laws, how they're more stringent, all of those types of things, and just the foundational cultural belief and practice that those things are absurd to even be talking about with the tribes. But so I think the kind of justification and approval process that often takes place through these things can always lead down a path of the best way to kill a bill, as you all know, is in any legislative process or government is just create a lot of doubt around it, create a lot of smoke that says, well, if we do this, we don't really know what all the outcomes could be, and then we end up scaring people. And then at the end of the day, there are multiple examples out there of tribal state relationships under total autonomous sovereign statuses that, sure, they have their issues from time to time, but they work. And they work because there's a mutual respect built that even at the end of the day, if we don't disagree, we're all in agreement that the tribes and the state have equal say in this. And sometimes if agreements can't be reached, they can't be reached. But at the end of the day, letting perfection get in the way of the good here is really going to be the challenge. So I just hope we have the political will to be able to say, this isn't a constituent driven process. This is a government to government responsibility. And while I appreciate everyone's concerns, and everybody's concerns should be considered, we have a responsibility to fix this. So I'm all for answering the questions in terms of what the tribe's priorities are, because I think we know what those are. We laid them out in the recommendations. But if we're looking for a 1 through 9 list or whatever it is, then I'm happy to talk about that too. But I think, as I spoke about earlier, it is a multifaceted, comprehensive approach to getting to success, and no one thing by itself is going to be able to address it in any kind of meaningful way. So that's why I was really appreciative of the committee in the 129th, in terms of understanding that there was tons of public process, there was tons of input, despite the fact that some were coming later saying, well, I didn't know that process was coming. There were multiple interests represented. And basically what I find is it's not so much the process that was the problem, it was more about the results. And so I think I would, it's a long way of saying, Senator, I'm happy to discuss priorities and what they mean and why they're so important, and hopefully we can get away from, this could happen and that could happen, and at the end of the day, because that's kind of the condition we're under now, except that the paradigm power is really all with state government, quite frankly, in terms of where we are. And to try to get those scales balanced a little more shouldn't be scary to anyone. It should be a day within a state that has a motto to lead, that it's an extremely important time and exciting time to set an example here of what we all stand for in a state that has the most Indian territory in it east of the Mississippi. So, and 4 extremely historical tribes in this state that make up the fabric of its heritage, and that can be celebrated by both sides in a way that helps elevate everyone. So that's why I'm here, and I would welcome any questions, and I'm willing to talk about, at least from a Penobscot perspective, where I think the priorities are, and always defer to the group of tribal leaders to set those formally. But I think we all have an understanding of where we are at this point. Thank you.
Yeah. Anybody else want to weigh in? I think what I would just love to comment a little bit. I think similar to, for example, Representative Sheehan and Representative Downs, in that we're new to the Judiciary Committee. We weren't part of the process last in the 129th legislature. And for me, I'm glad, Chief Francis, that you highlighted the four reports that you mentioned when you were speaking a moment ago, because I know that I've been doing a lot of homework to try to kind of catch up on where everybody was last summer in 2020. But there is a lot of groundwork for those of us who weren't part of that process to catch up on. And I think that was the motivation of my desire to think about priorities, because I know for me, it would give me a lens that I can use when I'm looking through the work that was done previously, kind of like, and I appreciate what Ambassador Dana said about the work that the Permanent Commission did last summer. I was part of that, and having that lens that helps me focus on the things that are most important, or the approach to all of the material that will help me understand the issues, and particularly your perspective on the issues. That's kind of what I'm looking for when I use the word priorities, which maybe is kind of a big, general, undefined word. But that's kind of where at least my perspective when I'm thinking about, wanting to hear some priorities. It's like, what can I be doing to best understand the situation, and where you would like us to be, but where you'd like us to be focusing on. So other committee members want to weigh in a little bit on what would be helpful to you? Not seeing anybody raising their hands. Go ahead, Chief Sabatis.
I was just going to say, I think, for at least in the past couple of years, for people that are new, I don't know if this is useful. I know that they had provided in a nutshell that really talks about federal Indian law. It may make things a little more difficult. I'm not sure. I think we highlight, in the tables that were created, federal Indian law and how it exists here in Maine, how laws exist here in Maine with the tribes, and what the differences are. But I know that was something that was distributed as a resource as well. And I think that, as Chief Francis said, really, what we're looking for is equity. I know for our tribe, we want to be able to function like all of the other tribes and the rest of the nation are able to. I know there are nuances with some of them, but taking a look at that and what that relationship is like with other tribes and states, it's not perfect, but that's what we want. That's what we're looking for, at least like our tribe.
Yeah, thanks. That helps guide me in where to do my homework. I appreciate that. Jeff, Representative Evangelos.
Thank you. Thank you, Senator Carney, and thank everyone for these presentations. One thing that would be critically helpful to all of the members, I have my copy, but especially for the new members, if we could produce a paper copy of the recommendations of the task force, so that you could sit at home and read it. And it would allow the new members to get up to speed with the work done in the 129th. One of my fears is that the recommendations are going to get cut up into small pieces, resulting in crumbs rather than a full loaf. I also think that perhaps our committee could spend a session to talk to the new members about the work that was done and invite Senator Bailey to join us because she was the co-chair, and to help this is a huge education project for all of us, but it would just help the new members get up to speed. You know, I spoke briefly last week. You know, I don't want to go back to spring training on this. You know, we were in Major League Baseball, and we were literally in the bottom of the ninth inning. The committee voted out a bill with a strong majority, adopting, I believe it was the 24 recommendations. We were headed for the floor of the House and the Senate. We were ready to fight it out and take the debate to the floor. So one thing I'm going to need from the nations is that our starting point? Is that where you want us to start? Or if not, we should have another meeting, certainly, to hear you in terms of where you want us to start. I thought we ended up in a really good place. You know, when we had Senator Carpenter chairing the committee, and he got on board with all the recommendations. And Representative Harnett and I were like official observers. We weren't, we didn't have votes to participate in it. But you did remarkable work. And all of the nations and their attorneys provided compelling testimony as to why these recommendations are necessary. So I do want to hear from them where they would like the committee to start. And lastly, and this is difficult, but it's a concept that we all have to come to terms with, and it came out of the United Nations report. I think it was 2015, but don't quote me on the date. But it was a report on the a declaration of the rights of indigenous peoples and nations in our country. And the conclusion was that these rights are inherent, they're inviolable. And in my testimony in the last session, I told everyone that I felt embarrassed and ashamed that I even had a stake in this, knowing that the things we were debating and talking about were not anything that any white person in Maine has the right to recognize, when the fact is these rights are inherent, they're non-debatable, they're internationally recognized, they're recognized in 49 other states. And I just have a really hard time around that, notwithstanding the fact that we've got the Settlement Act and the Maine Implementing Act to deal with. So all I can tell you is, committee members and nations, you've got my commitment to pick up where we left off. I'll do whatever I can, along with Representative Harnett and the other members of the committee, to get us all up to speed to a place where we understand where we were, and then listening to the nations as to where they want us to begin, or whether they want us to get the umpire to put the game back in play at the bottom of the ninth inning where we left off. I was devastated when we went home. This was the most important issue of the entire session for me. And as Chief Sabatis and Chief Dana stated, it was pretty devastating not to finish the game. So that's all I got to say. I think our committee needs to help each other and work by getting a paper copy of the task force recommendations, help us all understand what was accomplished, and then listen to the nations. And this will probably take more than one meeting, but listen to the nations as to where their priorities are and whether they want us to go after the whole package or they have recommendations that differ from that. Thank you. Sorry that was so long.
Thank you, Representative Evangelos. Did Chief Sabatis go ahead?
Yeah, I thank you. I appreciate that, Representative Evangelos. And I think what I had said before too, the chart, I don't know if you all have that. It really lays out in specifically those recommendations, but it also lays beside it federal law and current Maine law, and then the recommendation. So, I think that's helpful even for people who don't understand the nuances of the Settlement Act and the implementing acts.
Yeah, thank you. Others wish to speak?
I would just add quickly, Senator, if I can, I think Representative Evangelos hits on a couple of good points. I think the problem legislatively really has been for the tribes over the years, and again, I've been working in the Maine legislature since 2000, and also, that this hiatus for this 7 years or so aside, what typically happens is, these bills, they keep getting kicked down the road. We're often, sent into carryover sessions, which are much tighter, much more intense, and we've not been able to. We've accomplished some things, and that should be acknowledged. I mean, there's been some accomplishments, but by and large, it's been tough to operate in that. And the representative mentions kind of where we left off. Ideally, I think for me, I would like to see us get caught up on where that leave off point was, and start our process with exactly where we were. So we're actually continuing to make steps in front of the full legislature, able to make these arguments. We got some issues to answer questions on that are priorities for us, around civil jurisdiction, taxation, and other things. And I'm not saying we shouldn't have those conversations, but I don't think it's necessary with all the history here that's been documented to start from square one. And he talks about the United Nations in terms of UNDRIP, and that's lays out the principles for how tribes are supposed to be treated, and was adopted by the United States. But at the same time, there is a special rapporteur report as well from Mr. James Anaya, who was tasked with evaluating Indian nations' relationships with the United States and with others. And Maine is specifically mentioned in that report. And they conclude a human rights crisis, actually, in this state in terms of how tribes are currently operating under the current structure. So again, there's a host of evidence out there, a host of documentation. And, I think in areas like criminal jurisdiction, we made tremendous progress with countless meetings with the Attorney General's office. I think we're really close on that issue in terms of everyone agreeing on that. Civil jurisdiction is a little more challenging, but the committee heard countless testimony and countless conversations on that as well as taxation, to be able to. And again, when I say these things are comprehensive, when you look at the taxation issue, for example, nobody is suggesting that the tribes can create these tax haven holes to create non-competitive or competitive disadvantages with anyone else. But what we are saying is we need to avoid things like when the person comes onto the reservation to purchase something, who's taxing them? Do they get taxed twice? And this dual taxation issue is been a big issue nationally. It's been resolved in a lot of places. Corey Albright talked about that in Washington State, how those tribes and that structure works. So we're at a competitive disadvantage now. And so when you, so all of those things are really part and parcel to trying to move forward in this. And so piecemealing it and knocking it down and doing all of those types of things doesn't really serve to accomplish what the legislative resolve sets out to do. So I would just close by saying that, as an example, the tribe here has been trying to develop alternative energy for close to 2 decades in our lands and around wind power and other things that we believed we had a product that could be harnessed in Maine that would be beneficial to Maine people, not just the Southern New England grid. We had a great company, but we got bogged down in who was permitting the project, who was going to get to tax the project, who was going to get to do all of those things. And there was no give on either side in terms, even though our permitting process was basically mirrored the state's, and we just added some cultural components to that in terms of what needed to be paid attention to. So ultimately our investor left, and the tribe still has this great product that could be beneficial to everyone. We couldn't get by who was going to be in control of it. And so I hope we can be in a different mindset than that. But I think civil jurisdiction, taxation, those things still remain top priorities for the tribes. And again, I would just point people to the extensive reports that are out there that I think can get us back to, okay, I understand where the finish line was last time, and let's just move from here. And those are just my thoughts.
Thank you very much. Chief Sabatis?
Yeah, I just wanted to, add to what Chief Francis was saying about, working with the state around even taxation. I mean, the Settlement Act references our ability to create agreements with the state around jurisdictional issues like taxation. So, I think that's something that, regardless of what happens here, we need to have ongoing conversation after this. It needs to be a constant partners at the table versus what's happening or what has happened over the last 40 years. But I also wanted to just say briefly, one of the experiences that stood out to me towards the end of the session last year too was discussion about making changes to internal Maine policy versus changes to the Settlement Act. And, I think that if you all can just keep in mind, while you're working on these things, that the real meaningful change comes when we make changes to this, and it takes away that paternalism that exists when we're making changes to this versus just looking at policy changes that are similar that can be ripped out from underneath us at any point.
Thank you. Representative Babbage, did you have a question or reflection?
Well,
Oh, and Representative Babbage, while you take a moment, can I just give Representative Hagan an opportunity to introduce himself?
Thank you, Madam Chair. I'm David Hagan. I represent the towns of Hamden and Newburgh, District 101. Thank you.
Thank you. Go ahead, Representative Babbage.
Yeah, I have 5 or 6 minutes, I think, of reflection that I'd like to share, just because I do have reservations, but I wanted this afternoon to be very, very positive, and so I didn't know if I should go ahead with this, but what's been said has been heartfelt, and I need to have people that are here today speaking about this know that my feelings are heartfelt too. I mean, as a social studies teacher for 40 years, as I've mentioned, much of what I discussed in the classroom or pursued, explored in the classroom was the greatness of this country with the terrible injustices that simultaneously existed throughout our development. And that included with Indigenous people, although I will confess, I think I have confessed in the past, much of what I spoke of was Western history or tribes that had, Trail of Tears on and so forth, a little bit of colonial, but sort of lost track of our local Indigenous peoples. So when I was anticipating this afternoon, I was thinking this would be wonderful for new members to get to meet people involved here and understand, but I think it's been very, very valuable to me, much more so than I would have expected. I just want people to know where I come from in this situation, because I hear about equality with the rest of the tribes. I mean, in my teaching of the American experience, I have always talked about inclusion, inclusion in society. And what this request is actually about is recognition of separation. When I think I've always talked about the American ideal of equal treatment, and yet what is being asked for is, as Maine citizens, because of ethnicity, to be immune from that equal treatment as far as Maine law is concerned. So understanding that the request comes from a very unique place, this is a new dilemma for me, and just a direction that's happened. But just to get to the meat of it, when I have always been concerned about gaming, and IGRA presents a problem for me because, much to my dismay, by a 50.4% vote of Maine people, we let casinos in the door in Maine. And because Maine has 2 casinos, national law says that any state that has casinos must allow Indian trust land to have casinos as well. That's only fair play, and I understand that. My preferred route would be to eliminate what I consider to be a predatory industry, because I think it's inconsistent with the Maine brand. But I totally understand that the tribes have to have economic development. I've never felt casinos were a proper economic development path, but understandably, many tribes, I don't think there's an Indigenous right to gaming, but many tribes have found success there. And the Penobscot people actually have Chief Francis.
Representative Babbage, we're in this in an informational session where we can't be debating specific legislation, and it sounds like you're kind of going in that direction. And if you could, also, I'm concerned that other people, for example, Representative Moriarty had his hand up, and I'd like everybody to.
Yeah, but listen, I'm pouring out my heart here, Madam Chair, and please don't interrupt. Well, I'm just going to wrap it up. I need people they need to know where I stand, because they actually have identified me as an obstacle to their goals. And I don't feel that I am, but I want them to know when I raise questions why I do. And, the other part of that is, I know the American Indian movement of the 70s and tribal recognition that happened in the 70s predated the land claim settlement. I was in Greenville in 1980. I was at the end of 8 years of teaching, and we weren't involved in the land claims specifically. It was part of the Kennebec watershed for some reason. But anyway, the point is, that I was aware of heightened tension as a result of that, and I really feared that the Native tribes were going to get nothing from that. So when they did get $81.5 million as a total allotment by the federal government, in my perception, I thought it a great victory. Understandably, there were things that were part of the settlement that have been interpreted to not be a great victory since that time, which I was unaware of in 1980. But as Chief Francis said, I didn't realize this, but there's more Indian land in Maine now than any other state east of Mississippi. I think that is in part because they were able to purchase these lands since 1980, and I'm extremely excited about that. Even in the amendment that I just had to 159, I looked up all those lands, and there still is some unpurchased designated land that they could purchase that are beautiful tracts in Washington County and then northwest of Moosehead Lake that I would love to see them reach their promised 150,000 acres each for the two tribes. So the UN Declaration does talk about self-determination. I don't know about sovereignty, but I appreciate a couple of the comments, like I think it was Chief Sabatis that talked about solving this through Maine policy rather than as an amendment to the Settlement Act. That is a dilemma I have. I'm trying to figure out what is it that Maine can't do regarding federal law of the last 30 or 40 years. I have been so excited about the task force and the recommendations they had, about the revitalization of MITSIC and where that's going. The fact that we passed VAWA last term was wonderful. And I look forward to a better future for every Indigenous person in the state of Maine. And I'm going to try to be on board with helping that happen. And if any of the tribal members or whatever think there's, this whole off-reservation tribal purchase thing as it works in other states, I'd be interested if anybody has any information or anything that they think I should read that would be on point that would help me to clarify my journey in learning information about this subject. So thank you very much, Madam Chair, for letting me finish. Appreciate it.
You're welcome. Thank you, Representative Babbage. Representative Moriarty, did you want to contribute to the conversation here?
Sure, I'll weigh in at this point. Thank you. In the 129th, I had the honor and pleasure of sitting next to Representative Newell in the IDEA committee. But nothing of my experience in that committee informed me as to the issues with which we're dealing now. In retrospect, if I had to be assigned halfway through the session, through the 129th, to a committee, it would have been Judiciary, so that I would be as informed as many, to the extent that you are, or many of you are. I honestly believe the Representative Evangelos has the right idea. And that is, he suggested we need to basically pick a beginning point, and that it needs to be much more recent than some point remotely in time. And instinctively, I agree that the end of last summer, when the committee last voted, would be a good point to begin, provided that we all have the background of the lengthy analysis and the multiple recommendations that were made prior to that point. And so I would, if it's necessary, and given the complexity of our scheduling, I'd ideally like to see some sort of special segment of our time devoted to an analysis of where the committee left off last summer. We're also in the awkward position of anticipating new legislation. And so we clearly don't want to devote a lot of time and energy going down a path that ultimately may not be part of the legislation. So timing is sort of important here. Although my sense is we can't be too far away from the new legislation, given the pace of events and the fact that the first section is moving rapidly along. But I think if we start with where we were last summer, that's a good place to get us to where we need to be. I do have one particular area of interest and of inquiry, and that is in the area of land purchase. I do want to know more about the idea or the concept of purchasing more contiguous land to that which is already owned, as opposed to parcels which are really relatively remote from what I perceive to be the historic tribal lands. And I don't know what the thinking either way is on that issue, whether it's just a matter of availability or whether there's something that would, to follow up on Representative Babbitt's point, something that would draw the tribes to northwest of Moosehead as opposed to somewhere in Washington, Hancock, or Worcester County. It's an area that I need to be better informed about. So I don't want to go on any further. That is my general sense that we need to focus on where we ended up.
Yeah, I think there's a lot of sound ideas in what you said, Representative Moriarty. Thank you. Other committee members have any contributions to the conversation or requests for pertinent information? Representative Harnett?
Thank you, Madam Chair. And just in response to both Representative Moriarty and Representative Evangelos, I think what Representative Moriarty is asking for should not be that hard to produce in terms of the votes that came out when the committee last met on August 6th of 2020 and match those up with the recommendations that I put, the consensus recommendations, and I put not a hot link, but the address for that in the chat. Because I agree, we have to move from where we ended up to honor the work that was done for the 2 years during the 129th. This is not, we cannot go back to square one, because we always seem to go back to square one and nothing ever advances. So I agree with both Representative Moriarty and Representative Evangelos, and I think that that's something we could set aside with the assistance of our analysts, set aside some time to see exactly where, what the consensus recommendations were and where we ended up, knowing full well this is a different committee and a different legislative session, but I think it's a very good starting place to get grounded. So anything we can do to make that happen, I think would be worthwhile.
Yeah, and I do think that we'll have legislation that will be similar to what the committee reported out. At least that's what I'm expecting. I haven't seen it, but that's my anticipation. And that kind of merges those two concerns about having a bill and what's our starting place. Representative Evangelos, I know you've had your hand raised, but you've had a chance to speak, and I was hoping you might let Representative Hagan speak prior to you speaking. Good, thumbs up. Okay, Representative Hagan, go ahead.
Thank you, Madam Chair. I agree that there was a whole lot of work done last year, and a lot of new knowledge was gained, and it was very fruitful knowledge to be had on the so many varying issues involved. But when COVID hit March 13th, my life took a little turn to the worse through sickening of family and death, and I was not able to attend. I was able to attend here and there, but not really able to attend in the summer. And other members also did not attend in the summer and missed all that. And we do have newer members, excuse me, on our committee that I think would benefit from not necessarily a square one, because we can certainly catch up with our reading and whatnot. But I think returning not to August, early August when those votes occurred, but to more of a pre-COVID, I wouldn't have a timeline in mind, just to help the members catch up, the newer members, and also to give me an opportunity to also catch up with what I missed from March 15th or whatever it was when we left. And that's all I have. Thank you.
Thank you for sharing that. Representative Evangelos?
Thank you, Madam Chair. Very briefly, I agree with Representative Harnett. Just as a matter of process, I think the members that don't have a copy, a paper copy, who's going to take responsibility for mailing them one?
I'll take care of that.
Okay, thank you. And just to let the new members know, each task force recommendation in that report had a vote. And so task force recommendation number 1, at the end of the recommendation, there was a vote. So you'll have 23 or 24 votes. And as I recall, they were all 9-1 or 10-0 in favor. So a paper copy will be so helpful. I don't need one, so anyone who doesn't need one, tell the chair, so they won't have to do a zillion copies. That's all I had.
Thank you, Representative Evangelos. I also wanted to let both members of the committee and our guests, the chiefs and Ambassador Dana, there is in our committee materials on our website, there is an extensive list of documents, but if there are additional documents that anybody thinks we need to include, we can certainly add those to that as well electronically. But I will make sure that everybody receives a printed bound version of the task force. And Representative Sheehan, would you like to contribute?
Yeah, I was just gonna say some of the resources that Chief Francis mentioned, I would love to see on that page. But I also wanted to acknowledge to everyone that I received a paper copy of this, and it's been my bedtime reading every night. I do not claim I'm just starting to catch up, but I do think that all of these resources are available to us. A lot of them are in this bound paper copy. Some are on our judiciary website, and that I see this catching up as a part of the work that I've, been doing for the last few weeks. And, it would be great to have everything in one place, but I'm finding access to all of these documents. It's just sort of a question of putting it at the top of my priority list. And I would love it if we could convene maybe short, study sessions to review questions people have among the committee, but just sort of acknowledging that this information is out there and that we can catch ourselves up on it.
Thank you. Representative Sheehan, I hope you don't mind if I ask you a question. When we had the session with our analyst where we were looking at the charts and we were focusing on the different areas, we didn't get to civil jurisdiction, but we did cover, for example, taxation. Did you find that a really helpful approach?
I did find it helpful, but I actually personally, I do a lot better sort of reading this material in advance and then coming together to discuss, just because, on the charts, they're super, super useful to me. But I actually I just find I'm able to critically comb through things on my own first, take some notes, and then regroup with everyone to sort of figure out what's not clear, what solutions have been proposed in the past, how folks feel about them. Does anyone have any new exciting ideas about, how to push for, substantive changes that could be even better? I mean, my instinct is I don't want to redo the work that was done. I think it's, as a new member, I don't think it's necessary for me. I don't want to to take steps backward on my account, I'll do the learning I need to catch up, and then we can push forward. That's my take on it.
Thank you. Thanks. That's helpful too. We're at 3 o'clock. I know that we anticipated wrapping up around this time. I guess I would like to start first with our guests and ask Ambassador Dana or any of the chiefs if there are any final words that you'd like to share with us. And I'll also extend the same to the committee, and maybe perhaps Representative Newell, if we could wrap up with any reflections that you have as a member of the committee. Does that sound like an okay process, everybody? Okay, all right. Who would like to be recognized? You can just unmute yourselves and speak, I guess.
Well, I'll just wrap up really quickly for us. As you can see, Madam Chair, from the conversation today, you can get into all kinds of complexities with this conversation, and I think it's indicative of the complexity of the issue. But I think we have made a tremendous amount of progress in educating not just this body, but people all around Maine. Tribes have really formed a lot of partnerships, and we're really proud of our relationships with Maine citizens in discussing these issues that face our community, and quite frankly, find it not uncommon with a lot of rural Maine. I think, for us, some of the nuances in terms of, what the tribes have received from the federal government in the Settlement Act, and what we're allowed to do in terms of trust land. You think about, $80 million split up among the tribes, and the ability to get 150,000 acres back is really, I guess, what perspective you're looking at it from is not really a success. I think that's a start, and it's when you're talking about 2/3 of the state of Maine and the billions of dollars in revenues off natural resources over the years, and the tribes, I will tell you, still possess much of those settlement funds in land acquisition accounts, in higher education accounts, and in trust fund accounts held by the federal government. And the ability to purchase land, for example, is there for us. And I thought Representative Moriarty hit it right on the head when we talk about contiguous lands that can be productive, that we can utilize, that doesn't take our membership 3 hours to get there to practice its cultural based activities. So there's a whole host of issues that we have to consider in these things, and I look forward to the conversations. I think this was a good conversation today, and I'm willing to participate at whatever level you all deem necessary, and try to do as much as we can to convince and educate people that this is about growth for all of us, not just the tribes of Maine. And while all negotiations can create some heartburn for both sides, I think that's where we need to be in terms of getting to a product that's really meaningful. It can't be that one side is totally comfortable with everything that's being decided. We recognize, just in closing, that we're in a coexisting society. We understand that. We understand the Penobscot River and the Penobscot River Valley is a resource that Mainers cherish, that we cherish. We've cherished our relationship with folks in utilizing those resources. All we're really trying to say at the end of the day is that the protection and the rights and the recognition of the unique and distinct status that exists within this state, so that Penobscot people, tribal people can maintain their identity in terms of who they were ancestrally as the ancient people that we are. And it's also about the rights of our kids to be that in the future. So every time one of those things slip away, we just become like everyone else. And I think that's a shame for everyone. So I appreciate the conversation. These are serious issues that go well beyond dollars and acres of land. It goes at the very core of who Native people are in this state and the importance of protecting that. So I appreciate it, Chairwoman, and I'm happy to be a part of these conversations.
Thank you very much. Chief Sabatis or I don't think Vice Chief Sillaboy is with us anymore, or Ambassador Dana, would you like to speak before we conclude today?
I would just like to say thank you, and I appreciate the conversation and the opportunity to get to know some of you a little better, and I am available and I will do what I can to be a resource for education, for any questions you might have, and I'm looking forward to moving forward with this. So thank you.
Thank you very much. Ambassador Dana?
Yeah, I would echo all of those thoughts. Thank you for hosting us today. And I think that this was a great kind of icebreaker on the whole thing. And sometimes you have to break ice with a sledgehammer. So we got right into some really meaty things today, but very, very important things. And I would just add that I know that the Settlement Act has kind of been the law of the land for 40 years now. And it's really the only thing a lot of people have to go by when it comes to Indian law in Maine. So I'm really proud of lawmakers that are kind of stepping up and learning about federal Indian law, because it is a really big task. And I know that myself and other tribal leaders will be here to be helpful as we go through these next set of bills. So thanks again. Looking forward to further discussions.
Thank you very much. Let's see. Any committee member wish to contribute before we close? Representative Newell, are you okay if I recognize you at this point?
Absolutely, Madam Chair.
Thank you.
Thank you so much. I just want to show appreciation of the time regarding this discussion to both the chiefs. Very grateful for the chiefs to coming into this conversation, as well as the committee members. I think it's very important, and I'm glad that we had this afternoon to have this discussion. I think from listening in, I think I identified, some points that I think I want to add to in regards to resources. I'm appreciative, to the committee's website of the number of resources that are available. I would also say that the Maine Indian Tribal State Commission has a large number of resources that may be available. And I want to just kind of highlight two different things that I heard this afternoon, and I'm wondering to both the chairs, the possibility of an overview in regards to UNDRIP and a potential overview of the federal trust responsibility. I think what we heard today was history just a little bit prior to, the Settlement Act. But I think if we learned a little bit more about the federal trust responsibility, I think we could learn more about tribal state relations. I think we heard from the committee members, and I think we've heard from the chiefs as well, as try to establish that starting point. So I think that's important to identify what that starting point is. But it's also important that the committee members are educated on the subject. And as we heard from the chiefs, the chiefs are more than available, to enter into further discussions and be available. So I think that's it, Madam Chair. And I just again want to say thank you. Thank you for this opportunity. I'm beginning to truly appreciate my place on this Judiciary Committee as we move forward in this legislative session. Thank you so much.
I was muted. Thank you, Representative Newell. And I think that we have reached the end of our meeting. And Representative Harnett, go ahead. Tom, you like me, you are muted like I was.
Sorry about that. We just received I received an email from Paul Tebow at mitsic.org, has all of the resources that Chief Francis mentioned and that Rena Newell echoed in her closing comments. So it's another place to get them. mitsc.org.
Thank you very much. And we are Representative Evangelist. Would you like to have the last word before we close?
No, I don't want the last word. Tom, I don't see it in my inbox, so could you forward it to the rest of the committee?
I'm sorry, the email didn't go to everybody. It just came to the chairs. It's mitsic.org. I'll forward it to the committee.
Yeah, we'll make sure everybody has that. Thank you so much, Representative Newell, for your closing words. And thank you. Great gratitude to the chiefs and to Ambassador Dana for joining us today. We appreciate you taking such a big chunk of your afternoon. Thank you.
Thank you.